Good morning. Can everybody start lining up for the photo?
Good morning. The time for convening has arrived. The Senate will come to order. Recognize, where's our chairman over there? He getting fitted for a neck brace already after falling back there? But hey, let me get everybody's attention real quick while we're waiting on the rules chairman. Senator from the 55th, Senator Mangum, had an emergency this morning of some sort. He had to be taken to Grady this morning. We don't know any of the details other than he was being attended to by paramedics earlier today. So, and when we find out more information, we'll post everybody. But just to let everybody know, Senator Mangum is at Grady Hospital right now. So y'all keep him in your thoughts and prayers, and as soon as we get updates, we'll notify the chamber here. So hope everything's okay. Recognize the senator from the 6th, reading of the journal.
Good morning, Mr. President. Happy 21st Legislative Day on February 21st. Got a great lineup of pages today. Out of College Park, we got Maya Leathers. Out of Douglasville, Kyle Ricard. Out of Crawfordville, Leonardo Cervantes. Out of Sharpsburg, Chase White. Out of Atlanta, Dominic Aiden. From Milton, we have Bryce Baisden. From Marietta, we have Mahika Chauhan. Out of Johns Creek, Tricia Gondagula. From Decatur, Madeline Martinez. From Atlanta, James Wynn Lamb. From Bloomingdale, we have Ryan Shea. From Powder Springs, Roxanne Rowe. From Johns Creek, we have Vibhor Gupta. From McDonough, we have brother and sister Jackson and Jillian Butchek. From McDonough, we have Trindo Storton and Daniel Wright, whose mama is Gina Wright over in our redistricting office. From Hazelhurst, John Wesley Waters. And from Hazelhurst, Cat Waters. Mr. President and members of this body, y'all give these pages a big round of applause. We look forward to serving with you guys and girls today. Mr. President, the journal has been read and found to be correct.
Thank you, Senator, and thank you, Pages, for being here today. We appreciate each and every one of you, so we appreciate y'all being here today. Is there objection to dispensing of the reading of the journal? Chair hears none, and the reading of the journal is dispensed with. Is there objection to confirmation of the journal? Chair hears none, and the journal is confirmed. All senators who have bills and resolutions to introduce, please bring them to the Secretary's desk. First reading and references of Senate bills. Mr. Secretary.
Senate Bill 221 by Senator Still, the 48th, and others. The bill is being titled an act to amend Chapter 24A of Title 43 of the Official Code of Georgia Annotated related to massage therapy
Regulated
practice.
industries.
Senate Bill 222 by Senator Davenport of the 17th and others. The bill is being titled an act to amend Title 30 of the Official Code of Georgia Annotated.
Health and Human Services.
Senate Bill 223 by Senator Jones II of the 22nd. A bill is being titled an act to amend Article 1 of Chapter 3 of Title.
Judiciary.
Senate Bill 224 by Senator Harrell the 40th and others, bills to be entitled an act to amend Part 5, Article 4 of Chapter 11 of Title 16 of the Official Code of Georgia Annotated.
Judiciary.
Senate Bill 225 by Senator Anderson of the 43rd and others, bill to be entitled an act to amend Article 1 of Chapter 1 of Title 20 of the Official Code of Georgia Annotated related to
Education and Youth.
Senate Bill 226 by Senator Huffstetler of the 52nd and others, bill to be entitled an act to amend Title 34.
Retirement.
Senate Bill 227 by Senator McLaurin of the 14th, bill to be entitled an act to amend Title 34 of the Official Code of Georgia Annotated related to
Insurance and labor.
Senate Bill 228 by Senator Estevez of the 35th and others, bill to be entitled an act to amend Article 3 of Chapter 17 of Title.
Banking and financial institutions.
Senate Bill 229 by Senator Anna Vitarte of the 31st and others, bill to be entitled an act to amend Chapter.
Regulated industries.
Senate Bill 230 by Senator Still of the 48th and others, bill to be entitled an act to amend Article 3 of Chapter 3 of Title 4.
Insurance and labor.
Senate Bill 231 by Senator Anna Vitarte of the 31st and others, bill to be entitled an act to amend Code Section 16.
Judiciary.
Senate Bill 232 by Senator Jones of the 10th and others, bill to be entitled an act to amend.
Judiciary.
Senate Resolution 231 by Senator Albers of the 56th and others, resolution honoring the life of Officer Jeremy Labonte and dedicating an interchange in his memory and for other purposes.
Transportation.
Senate Resolution 237 by Senator Hickman of the 4th and others, a resolution urging the Professional Standards Commission in collaboration with the Department of
Education and Youth.
Mr. President, that completes the order.
First reading references to House bills.
House Bill 51 by Representative Burchett of 176 and others, a bill to be entitled an act to amend.
Regulated industries.
House Bill 53 by Representative Bonner of the 73rd and others, a bill to be entitled.
Veterans.
House Bill 73 by Representative Green of the 154th, a bill to be entitled an act to amend an act creating.
State and local government.
House Bill 85 by Representative Leverett of the 123rd and others, a bill to be entitled an act to amend Article.
Judiciary.
House Bill 86 by Representative Leverett of the 123rd and others, a bill to be entitled an act to amend.
Judiciary.
House Bill 90 by Representative Estration of the 104th and others, a bill to be entitled an act to amend Code Section 48-5-7.4.
Finance.
House Bill 116 by Representative McDonald III of the 26th and others, a bill to be entitled an act to amend Article 5.
Transportation.
House Bill 147 by Representative Thomas of the 21st and others, a bill to be entitled an act to amend Chapter 25. of Title.
Economic development.
House Bill 155 by Representative Anderson of the 10th and others, a bill to be entitled an act to amend Article.
State and local government general.
Mr. President, that completes the order.
Secretary will read reports of standing committee.
Mr. President, the Senate Committee on Education and Youth has had under consideration the following legislation, has instructed me to report the same back to the Senate with the following recommendation. Senate Bill 4, due pass by substitute, respectfully submitted, Senator Payne of the 54th District, Vice Chairman. Mr. President, the Senate Committee on Judiciary has had under consideration the following legislation, has instructed me to report the same back to the Senate with the following recommendation. Senate Bill 97, due pass. Senate Bill 57, due pass by substitute. Senate Bill 42, due pass. Respectfully submitted, Senator Strickland of the 42nd District, Chairman. Mr. President, the Senate Committee on Regulated Industries and Utilities has had under consideration the following legislation, has instructed me to report the same back to the Senate with the following recommendation. Senate Bill 33, due pass by substitute. Respectfully submitted, Senator Cowser of the 46th District, Chairman. Mr. President, the Senate Committee on State and Local Governmental Operations Local has had under consideration the following legislation, has instructed me to report the same back to the Senate with the following recommendation. House Bill 236, due pass. House Bill 356, due pass. Senate Bill 161, due pass. House Bill 252, due pass. Respectfully submitted, Senator Dixon of the 45th District, Chairman. That completes the order, Mr. President.
Secretary will read bills and resolutions for the second time.
Senate Bill 116 by Senator Bearden of the 30th and others, DNA sampling, the collection of DNA samples from any individual in a detention facility charged with a misdemeanor or felony who is subject to an immigration detainer notice require. Senate Bill 129 by Senator Albers of the 56th and others, Georgia supporting those who sacrifice for service act, enact. Senate Bill 130 by Senator Hodges of the 3rd and others, health, medical, education funding, and the Service Counselable Loan Program, expand. Senate Bill 140 by Senator Dolezal of the 27th and others, optometrists, doctors of optometry to dispose and sell pharmaceutical agents to patients under certain conditions provide. Senate Bill 141 by Senator Hatchett of the 50th and others, revenue taxation, the appeal and protest period from 30 days to 45 days for tax assessments extend. Senate Bill 160 by Senator Kirkpatrick of the 32nd and others, reckless stunt driving, a motor vehicle involved in a second offense of reckless stunt driving replaced the forfeiture penalty. Mr. President, that completes the order.
It is now time for the morning roll call. Are there any motions to excuse? No motions to excuse. All right. We will go ahead and excuse the senator from the 55th. Secretary will call the roll. Senator, signify your presence by voting the yay switch. Secretary, unlock the machine. It is now time for our morning devotion. All senators, please take your seats and cease all conversation. I would ask the doorkeepers secure the chamber at this time. I now recognize my senator, the senator from the 25th, to introduce our chaplain of the day and lead us in our Pledge of Allegiance. Senator?
Thank you, Mr. President. If you'll join me in the Pledge of Allegiance to the American flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And the Georgia flag. I pledge allegiance to the Georgia flag and the principles of which it stands, wisdom, justice, moderation, and courage. Thank y'all, everyone. It gives me great pleasure to introduce my pastor, Mac Enfinger. He grew up in Blakely, Georgia, located in Early County. He earned a Bachelor of Science in Chemistry with a minor in Business Management from the University of Georgia. In 1997, after 20 years of making rosins, pigments, and additives to paints and plastic manufacturers, he felt a calling to the ministry, sold his chemical plants located in Cobb County, North Carolina, and Florida, and he earned his Master of Divinity degree from Emory University Candler School of Theology, and earned his credential as an oncology and stroke victim chaplain at the Tri-Hospitals of Northside Children's and St. Joseph's Hospital in Atlanta. He's ordained Methodist. Reverend Enfinger served at Dalton First, Wesley and Augusta, Royston, and the last 11 years at Millersville First Methodist. Pastor Mack is married to Amy Bowen Enfinger from Larry Bird Country in Paoli, Indiana. They have 2 children, Trey and Augusta, and Aaron and Alpharetta, 3 granddaughters, an avid dogs fan, season tickets 49 years and counting. So he enjoys golf, spending time out on Lake Sinclair, and I'll introduce Pastor Mike Enfinger. Thank you, sir.
Well, good morning. The last time I was here at the Capitol, I was thinking came up from Blakely on a Bluebird bus when I was in high school. And I was thinking it was quite the trip, as they were in those days. It broke down on the way back, and good thing was in those days we had those cooler boxes full of sandwiches, and I'm not sure how it all ended up, but it's good to be with you here this morning. I want to read a piece of scripture to you. It's one out of Ephesians 4, and really I think it sort of sums up what Paul. Really all of his writings, if it hadn't been for his call to unity, he probably wouldn't have written anything over, as you see, all of his letters, all of the epistles that he wrote. So listen in just to these words. It's the 4th chapter, 3rd through the 6 verses. Paul said, "You are called to travel on the same road and in the same direction. So stay together both outwardly and inwardly. Make every effort to keep unity of the Spirit. Keep into the hope that you're called. There's one Lord in Jesus Christ, one faith, one baptism, one God and Father of all, who rules over all, who works through all, and is present in all. Therefore, in everything that you are, you think, and you do, remember your call towards unity of the Spirit." So when Senator Williams asked me to come, I was thinking to be chaplain of the day, trying to think of an image, some image I might want to leave you with, something that might remain, something that kind of help you press forward with your agendas, that enable you to, perpetuate this unity of the Spirit with your colleagues. I thought that you probably won't remember my words, but if I give you some image, maybe it'd be helpful. as you consider your efforts to work together for the common good that you're here for. And that's what you do. That's my perception as a citizen of this state. I was thinking you give up time, so much time, for your family and your work to be here, that we Georgians will have a better opportunities and a better life and a better future. And we do appreciate you for all that you give up and all that you do for us. I remember once I was asked to speak at an MBA class when I was in Augusta, and they wanted me to come in and talk a little bit about why and how my business was successful. And, I go in, I have the things that you normally would say, and they said, hey, what made your business different? What do you think was the difference? And I said, well, at the end of the day, it was people. It was we remembered that we gave people lives. If we didn't exist, there were a lot of people that wouldn't have jobs, and there are a lot of people that would not feel valued. And that was one of the things that we did. And all of that, our whole point was to create unity, that we would all be working together for the common good. Because I had everything from truck drivers to secretaries to chemists. All these different personalities, but any one piece not working together, we wouldn't be successful. But I think enabling one another to know that they are valued for who they are and what they do in every spot along the way enabled us to be unified in what we did. Thinking 7 years ago, you may not know this, or you may. 7 years ago, on this day, we lost Billy Graham. He really messed us up a little bit, because who says the young they really get it. The good die young. And then I thought about how tomorrow is the 22nd. And we're going to celebrate some remarkable people tomorrow. One that is George what? Washington, right? The other one that you might not know is 240 years later was Drew Barrymore, who played Cinderella. And I started thinking about American Dream. Started thinking about how from nothing, one became president of our country and the other became princess. But for me, when I really think about the 22nd, it reminds me of someone even more remarkable in my life, which was my granny. And she was born February 22nd, 1901. And she had a good life, but a tough life. My grandfather died when my dad was 12, had about 6 kids, and growing up in South Alabama, it was really difficult. But she managed, and that's how she was. One of the things that for her, though, that I remember in my mind's eye is when we get up and we'd be over at Grandma's and you come up, she'd be in that little kitchen, that pine panel thing. She had a little place where she sat, and the little 7-up clock that was back there went tick, tick, tick. You could just hear it. I could just see it in my mind's eye, but she'd be sitting there reading her Bible. She was always there searching the scriptures. And I remember asking her once, what are you doing? Because, I was young and whatnot. And she said, I'm just giving thanks to God that I have children that work together to make sure that I have a home and I have something to eat. Paul said, make every effort to keep unity of the Spirit. And I'd add, for the common good. I thought about how we pastors have a lot in common with you, and same but different. We're all sort of elected to our spots at where we are. We are all have a lot of bosses. We have a lot of people that expect a whole lot of us. And I think we all try to put our best foot forward in everything we do. But this day is characterized, as we know, by division and conflict, right? Just a lot of it out there. And no matter how it is, everywhere I turn, there seems to be some fly in the ointment. There's always something that somebody wants and something that they need you to do. And so what's the answer? I mean, what is the answer for us to do what we do, give our best, and be effective? And I think at the end of the day, it's our hope that's found in giving of oneself to the other for the greater good. To give people a life. So if you remember anything that I have to say today, just remember that unity is everything. And think about the people in your lives. Maybe it's your grandma, maybe it's your granddad. I don't know how it is, your family, and how it is that they appreciated life and how they grew. And because of the unity of the people around them, they lived fruitful lives. So let's pray. Gracious God, we give thanks this morning for your presence in our lives, and we come before you grateful just for the privilege of being leaders. Lord, for the faith that you give us, that we can continue to do your work with your wisdom and discernment and fulfill our responsibilities. So we ask for your guidance today in fostering unity among ourselves and those we serve. Help us to listen deeply and collaborate faithfully. And instill in us all every day a spirit of humility, that we might do what we do and serve with integrity and build bridges that enable people to have lives and a future. In Jesus' name, amen.
Amen. Good job.
Thank you.
Good job. Good job. Thank you. We have a special guest here, the doctor of the day. We always like to recognize our physicians that come down and volunteer their time to the General Assembly. And I want to call on the senator from the 32nd to introduce our doctor of the day.
Thank you. Good morning, colleagues. I want you all to meet my neighbor, Dr. John Gibson. He is a Georgia native, grew up in South Georgia, went to Teft Academy, and then he went to undergrad at the University of Hawaii. And then he joined the Navy. He was an electrician in the Navy, and he was in Desert Shield for a while. And when he got out of the Navy, he went to medical school and did his undergrad in Hawaii, and then went to Emory for his residency and did his cardiology fellowship at Vanderbilt. He works for the Kaiser Permanente Medical Group. His office is in Kennesaw. He does non-interventional cardiology, so if any of y'all get chest pain during our session today, you can go see Dr. Gibson and he will get you straightened out. Thanks very much for being with us. Come and say hello.
All right.
Thank you for the welcome. I just wanted to thank you, Kate, for how much work you've done with us in the MAA, in the MAG, and you've been just such a strong advocate for patients in Georgia, and so thank you for that. That message this morning really resonated with me about unity. When I grew up in Georgia, I grew up in rural Georgia, and there wasn't a lot of money, and we quickly learned that we needed help. And we quickly learned thereafter that if we helped others, we did better. And that's what I want to be most appreciative of you, the sacrifices that all of you make with your families and your jobs to be here. It really makes a big difference in the lives of Georgia. So thank you. Thank you all for doing what you do and for allowing me to be here this morning and hopefully provide some level of service to you. You guys have a wonderful morning.
All right. Good job. Are there any unanimous consents? Does any senator wish to rise on a point of personal privilege? Nobody signed up. You have a consent calendar of privilege resolutions. Does any senator wish to remove a resolution on the consent calendar? Recognize the senator from the 17th.
Thank you, Mr. President.
Hold on, Senator, I'm sorry. We need to adopt these first real quick. Just 1 second. Just stand by. Is there objection to the adoption of resolution of the consent calendar? Chair hears none. The resolution of the consent calendar is adopted. Now I recognize the senator from the 17th.
Thank you, Mr. President. I ask for unanimous consent that Senate Rule 4-21 be suspended to allow for the first reading of a resolution. Please.
Without objection, Secretary, read the caption.
Senate Resolution 240 by Senator Davenport of the 17th and others, a resolution recognizing and commending the Jonesboro Majestic Marching Cardinals and for other purposes. That completes the order, Mr. President.
Is there objection to the adoption of the resolution? Chair hears none, and the resolution is adopted. Are there any motions to withdraw or commit? You have before you a consent calendar of local bills. Mr. Secretary, if any objections have been filed on any of the bills on the local consent calendar?
Mr. President, no objections have been filed.
Is there objection to the agreement of the Reporting Committee on State and Local Government Operations, which is favorable to the passage of the bills on the local consent calendar? Chair hears none, and the Reporting Committee is agreed to. The question is on the passage of the bill on the local consent calendar. All those in favor will vote yea, opposed nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 46 and nays are 0. The bills on the local consent calendar, having received the requisite constitutional majority, is therefore passed. Senator from the 3rd, did you wish to have a point of personal privilege?
Thank you. Thank you, Mr. President. Colleagues, I rise to let you know that on your desk you'll have the 2024 annual report for Jekyll Island. I commend it to you for looking at. If you visited Jekyll Island 20 years ago and then you visit it today, you would not know the difference. So they have done some really wonderful things in the Golden Isles and Jekyll Island. Also, there you will receive in your office this little seedling. It's being delivered by the Jekyll Island folks to your office. This is a seedling from the oldest oak tree on Jekyll Island. So plant it and grow your own oak tree, courtesy of our friends at Jekyll Island. We appreciate your support and invite you to come down and visit with us. Thank you. Mr. President, I yield the will.
Thank you, Senator. Senator from the 19th, do you have some points of personal privilege? It's already passed, Senator, but come on down and speak your knowledge.
There's very little knowledge here, Mr. President, but thank you. Members of the Senate, I'd rise for two reasons. One, Jackson in the back at Senate Press. It's his birthday today. Happy birthday, Jackson. What a time to be alive. And also, many of you know Mr. Moses Williams. He runs the housekeeping services, the contract here at the Capitol. He turned 69 today. Mr. Moses, we know you're out there working somewhere. Thanks so much for what you do to keep everything looking great for us here. Mr. President, I yield the will.
Senator from the 28th, you wish to speak? You just want to speak from your desk there? because we've already passed the points of personal privilege, I've just been making exceptions for everybody right now, so.
Thank you, Mr. President. I appreciate it. The Black Caucus assigns all of us a day to talk about Black history. And as you know, Black History Month is February, a time to recognize the people's ideas and events and everything that brought us to where we are today and that has shaped our society. I want to reflect on what this month means to millions of Americans who observe it. Black History Month started as Negro History Day. That was Carter G. Woodson worked on for many years. In 1976, Gerald Ford officially recognized Black History Month, which has since become a time to honor the individuals who have shaped our history. Georgia has been the home of so many of the great leaders who worked for years to make a positive difference in bringing unity to the United States of America. Born in Atlanta in 1929, Reverend Dr. Martin Luther King Jr. led the Montgomery bus boycott, the Southern Christian Leadership Conference, which is SCLC, the March on Washington, just to name a few. His unwavering fight for justice made him one of the only Georgians to win the Nobel Peace Prize, and the other one being President Jimmy Carter. Dr. King lived only a few miles from this very spot where we are today, and he fought for civil rights. His father had the Ebenezer Baptist Church, in which he inherited many years later. And his loyal and faithful wife, Coretta Scott King, took the mantle when he was assassinated and continued his work and built her legacy, advocating for civil rights and economic justice. Ralph David Abernathy, a close friend of Reverend Dr. Martin Luther King and co-founder of the Southern Christian Leadership Conference, placed a key role in the Montgomery boycott. And of course, we must not forget Rosa Parks, whose quiet defiance in 1955 sparked a powerful and eternal movement. Her arrest spearheaded the important Montgomery boycott, and she pivoted continuously from one area to the other, trying to make a positive difference and in the civil rights movement. She continued her advocacy throughout her life, fighting for justice and equality in the South and beyond. While these individuals were true trailblazers, I also want to take a moment to recognize the many Georgians whose efforts go unrecognized. We must always recognize, and I said that because my great-grandmother, Lou Ellen Slappy, and her sister, my aunt, great aunt, owned the Royal Peacock and that whole 2 blocks on Auburn Avenue, and it still exists today. And they were AME members, and my aunt was the first woman to be a treasurer of the AME movement. But I had much more to say about Black history, but I appreciate you listening to the Black History Moment for today. I'm Senator from the 28th, and I'm proud and honored to be an Atlantan, Grady baby, too young to march in the movement, but I cheered them on because I was alive at the time that they were marching in the civil rights. So let us all come together and let us never forget that Atlanta, Georgia is a great place for the whole, globally, for the whole world. Thank you.
All right, last one right here, because we've already passed the points of personal privilege. I've just made some exceptions to a couple of the members here, so the floor is yours, Senator.
Thank you, Mr. President. Just to remind you, to my colleagues, today, February 21st, is the 25th anniversary of International Mother Language Day. It was initiated by the people of Bangladesh and the folks that speak Bengali languages that I speak at home. This milestone highlights the quarter century of dedicated efforts to preserve the linguistic diversity and promote the use of mother tongues. It served as a significant opportunity to reflect on achievements, renew commitments, and emphasize the critical role of language preservation in safeguarding cultural heritage, improving education outcomes, and creating more peaceful, sustainable societies. Thank you, Mr. President. I yield the word.
Thank you, Senator. Moving on to the rules calendar. Secretary read caption for Senate Bill 10.
Senate Bill 10 by Senator Goodman of the 8th and others, the bill to be entitled Act to amend Code Section 15-6-2 of the Official Code of Georgia annotated related to the number of judges of superior courts, so as to provide for an additional judge of the superior courts of the Alapaha Judicial Circuit, to provide for related matters, to provide for effective dates to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Brass, the 6th District Chairman. Mr. President, the Senate Committee on Rules offers the following substitutes to Senate Bill 10, a bill to be entitled an act to amend Code Section 15-6-2 of the Official Code of Georgia annotated related to the number of judges of superior courts, so as to provide for an additional judge of the superior courts of the Alapaha Judicial Circuit, to provide for the appointment and term of such additional judge by the governor, to provide for the election and terms of successors to the judge initially appointed, to require candidates for such judgeships, and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 8th. Just waiting on you, Dirt Road.
Sorry about that, Mr. President. I have before you Senate Bill 10. All it does is it adds a judgeship to the Alapaha Judicial Circuit. The Alapaha Judicial Circuit is leading amongst all circuits in need for an additional judgeship. There has not been one added since 1979, and again, it's the number one in need according to the Judicial Council. And with that, Mr. President, I'll be happy to yield for any questions.
You do have one question, Senator. I recognize the senator from the 33rd.
Thank you, Mr. President. Does the senator yield?
Yes, sir, I do, to my great friend from the 33rd.
How many judges will that give you on Blueberry Hill?
I'm not sure about that, Senator. on Blueberry what Hill?
Yeah.
We'll have 3.
3?
Yes, sir.
Well, you got my vote.
You have no more questions, Senator.
Thank you, Mr. President. With that, I ask for your favorable consideration. Thank you, my friends.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. Senator from the 41st, for what purpose do you rise?
38, right? I ask for unanimous consent to excuse the senator from the 38th.
Without objection, Senator from 38 is excused. On the passage of the bills, the yeas are 49, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary Reed, Senate Bill, caption of Senate Bill 12.
Senate Bill 12 by Senator Ginn of the 47th and others. Bills being entitled Act to amend Article 4 of Chapter 18 of Title 50 of the Official Code of Georgia annotated related to inspection of public records so as to provide provisions related to documents and records in the possession of private persons or entities, to revise definitions, to provide provisions related to judicial enforcement of inspection requests, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland, Chairman. Mr. President, the Senate Committee on Judiciary offers the following substitutes. The Senate Bill 12, a bill to be entitled an act to amend Article 4 of Chapter 18 of Title 50 of the Official Code of Georgia annotated related to inspection of public records, so as to revise provisions related to public records in the possession of private persons or entities, to revise definitions, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. That completes the order, Mr. President.
Recognize the Senator from the 47th.
Good morning and happy Friday. You know, it's really a great day because it is Friday, and I know everybody in here put on their best look because you all got your picture made this morning. I'm here to bring you Senate Bill 12 and ask for your favorable consideration. One of the things that I learned a long time ago, never argue with a judge. And when the Supreme Court in Georgia this fall came up with the ruling that said it was a little unclear in the law as to where an open records request would be made, then I looked at it and I said, okay, well, let's support their ruling and let's clarify it in the law. The Senate Bill 12 does a couple things, and I'd point out on your desk with all that paperwork that you got on your desk, you got a couple letters of support from the Georgia Chamber, the Metro Atlanta Chamber, you've got Hub Chamber, and then you've got a little sheet that's an explanation of the bill from even our Georgia Press office, the Senate Press Office. But in a nutshell, the bill is real simple. It makes sure that if you want to make an open records request, that you go to the government agency which you're dealing with. That would be a city, a county, state agency, development authority, whatever the government entity is. And the reason that open records request is an open records request because we're spending taxpayer money. I've long fought for government in the sunshine, and this is one of the things that clarifies that. Working with my local news agencies and newspapers, they're in support of the bill. I've asked them, I said, have you ever gone to a private contractor? They said, no. I said, well, what this does is make sure that you go to that state agency, you go to that local government, you get your questions answered. They have time-sensitive things to respond. Usually they have a records retention person. This bill will handle that, and I'll be glad to answer any questions that somebody may have about the bill. Said
You do have one question, Senator. I recognize the Senator from the 42nd.
Thank you, Mr. President. The Senator yield.
My Chair of Judiciary, I'll be glad to yield. I appreciate all your help on working through this bill, Mr. Chairman.
Senator, I appreciate your work on this bill that we worked on in our committee together. Just to confirm, under the current law, did your bill change the definition of an agency as far as those that have to comply with open records laws?
Not at all.
You yield for more questions?
Yes, sir.
Does your bill just confirm that when someone sends an open records request, it needs to go to the agency and not to private citizens who don't have the capability of dealing with constant open records requests being sent to them?
That's exactly correct. I don't care if you're cutting the grass around City Hall, you're fixing potholes, or whatever service you're providing to the local government or the agency. So that question goes to the agency, and the bill also goes on with your help. We added a sentence in there that says such private persons or entity shall be required to produce such public records to a custodian upon request from such custodian.
That was my, if you can, my final question was going to be just that. So with your bill now, we're making certain that agencies have this responsibility of getting these documents as well. So aren't we actually making it easier for the public to get open records with your bill?
Very much so.
Thank you.
Thank you for your questions.
You have no further questions, Senator.
I'll ask for your favorable consideration. Thank you, Mr. President.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those who will vote in favor will vote yea. All opposed, nay. Secretary will unlock the machine. On the pass of the bill, the yeas are 49 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary will read the senator from the 47th. For what purpose do you rise?
Mr. President, I want to check the senator from the 53rd's machine. I was surprised there was a green vote on that, but I was really pleased.
Well, you know he likes you, Senator. Secretary, read the caption of Senate Bill 68.
Senate Bill 68 by Senator Kennedy of the 18th and others, a bill to be entitled an act to amend Titles 9, 13, 40, and 51 of the Official Code of Georgia annotated related to civil practice, contracts, motor vehicles, and torts, respectively, so as to provide for substantive and comprehensive revision of provisions regarding civil practice, evidentiary matters, damages, and liability in tort actions, to provide limitations relative to pain and suffering testimony, to provide for timing of answers and discovery, to provide for dismissals of civil actions, to provide for definitions, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland, Chairman. Mr. President, the Senate Committee on Judiciary offers the following substitute to Senate Bill 68, a bill to be entitled an act to amend Titles 9, 40, and 51 of the Official Code of Georgia annotated related to civil practice, motor vehicles, and torts, respectively, so as to provide for substantive and comprehensive revision of provisions regarding civil practice, evidentiary matters, damages, and liability in tort actions, to provide limitations relative to evidence of non-economic damages, to provide for timing of answers and discovery, to provide for dismissals of civil actions, to provide for attorney's fees, court costs, and litigation expenses, to provide for admissibility of evidence, and for other purposes. Mr. President, a minority report to Senate Bill 68 has been attached. That completes the order, Mr. President.
Recognize the pro tems, speak to the caption.
Thank you, Mr. President. Good morning, colleagues and others that are here today for a very important measure. I bring you Senate Bill 68 on behalf of our governor, Brian Kemp. In an effort to balance our civil justice system and stabilize costs for healthcare providers, job creators, and most importantly, Georgia consumers. You know, since 2016, the U.S. Chamber of Commerce estimates that the cost of litigation across this country has risen 7.1% year over year, and very sadly, that far outpaces inflation. In fact, the Chamber of Commerce also estimates that excessive litigation and nuclear verdicts cost Georgians roughly $5,035 per year per household. The impact of excessive litigation extends far beyond the courtroom. It reaches the small business owner who is faced with the difficult choice of laying off employees or even shutting down, all because their liability insurance premiums have doubled. It affects the pregnant woman who now has to drive over 2 hours to see her OBGYN simply because her local hospital had no choice but to close its doors. This is the harsh reality when healthcare providers are forced to leave the state due to the threat of frivolous lawsuits. The truth is, everything I've mentioned affects all of us, Republican and Democrat, young, old, male and female. Dear friends, 21 days ago, Governor Kemp held a press conference introducing this bill and naming it as his top priority of this legislative session. We witnessed hundreds and hundreds of people from all walks of life come to the Capitol and tell us why they need relief. Truckers, job creators, property owners, healthcare providers, businesses large and small sent a clear message on the Capitol stairs when they came. The status quo is not working for their business, their families, and all of Georgia. You know, inflation has drained family bank accounts, and insurance premiums continue to rise. Folks at home continue to struggle to make ends meet, and businesses continue to be faced with a serious risk of closing their doors for good. For those who have doubts about this bill, my message to you is simple. Do not buy the message that's being put out there by some who, quite frankly, benefit from the current civil justice system that we have, while the rest of our state is paying for it. Despite what you may have heard from the AJC's opinion page, this legislation is not about protecting corporate profits. It's not about caving to the demands of the insurance companies or denying Georgians their ability to be fully and fairly compensated when they need to go to court. Instead, it is about stabilizing costs and putting all Georgians, no matter where your zip code is, first. Don't believe me? Well, let's just look at some neighboring states. 2 years ago, the state of Florida passed similar legislation to what we are putting on the floor for your consideration today. And what happened? Florida saw increased competition in the marketplace, lower consumer prices, and they're already seeing the positive impacts of the tort reform measures they engaged in a few years ago. This year, the state of Florida announced significant decreases in auto insurance rates. State Farm announced a 6% decrease. Progressive Insurance Company announced an 8% decrease. And Geico announced a 10.5% decrease in the auto rates for the state of Florida. Florida has also recently announced that the lowest average homeowners premiums are the lowest of the entire nation. Senate Bill 68 is about expanding protection for Georgians, stabilizing costs, bringing competition back to the marketplace, and creating, quite frankly, simply a good business environment that we all want for Georgia. I will tell you, though, this legislation has not been crafted overnight. Commissioner John King, Insurance Commissioner John King, and legislative leaders did their job when they spent the last 2 years collecting data and participating in roundtable discussions around the state with businesses, healthcare systems, and everyday Georgians. Discussions around the bill, though, did not stop there. The governor said in his State of the State address there would be room for the legislative process to play out in the normal way that it does, and that input from all sides would be important to him, and the debate would be heard. The substitute you have before you today incorporates input from the Georgia Trial Lawyers Association and the plaintiffs' lawyers around the state. In fact, this bill is the result of dozens and dozens and dozens of hours of diligent work by the members of the Judiciary Committee, the Governor's Office, stakeholders from all sides of this issue, and others that wanted to be heard. This bill, as you have brought before you today, went before the Judiciary Committee, and it received an 8-3 vote from the Senate Judiciary Committee, and it is the bill you have in front of you today. So, let's talk about the bill. There are 8 sections in Senate Bill 68. I'm going to go through each section, do so briefly, but hopefully enough so that it makes sense to understand and identify what is the problem we're trying to address, what is the solution being offered in this bill, and why this is going to help Georgia and everyday Georgians. But before we do, I want to do a little bit of a tutorial, if you'll bear with me, maybe for the non-lawyers in the crowd. As a basic understanding of why some of these changes need to be made, in a civil action lawsuit, for the plaintiff to recover, no matter what the issue, what the wrong is, a plaintiff has to basically prove 2 things. One, that the defendant they have named in the lawsuit and hailed into court is in fact legally liable to them for some wrong. Secondly, the plaintiff must prove to a degree of particularity what are the damages that he or she has sustained. That's basic in all civil litigation. And if you look at the second half of that, the damage portion, there are 2 types of damages that plaintiffs can ask for that can be awarded. Number 1, general damages, and number 2, special damages. Special damages are kind of thought of as those economic damages, that they're calculable to a degree of a particular dollar, and think of it in terms of basically the reimbursement that should go to the plaintiff who's been wronged so that they can get a full recovery. General damages, though, are those, think of those non-economic damages, such as pain and suffering, which are often an element of a plaintiff's case in a bodily injury case or certainly wrongful death. Let's go to Section 1. Section 1 of the bill deals with something called anchoring. Well, what's the problem? The problem is that when a plaintiff brings a lawsuit, some of the damages are already quantifiable, as we just talked about, whether it's lost income, medical bills, or things of that nature. But the law also allows the plaintiff to recover for damages of pain and suffering, emotional distress, those non-economic damages I just talked about. And it's been a staple of our law that non-economic damages should be left to the enlightened conscience of a jury. I didn't make that up. That phraseology has been in our jurisprudence for centuries. Recently, however, attorneys on both sides have aggressively attempted to anchor a juror's mind to irrelevant or arbitrary information or amounts for damages. And that has produced excessively high verdicts, some of which we call nuclear verdicts that you hear about in the paper. So what is the solution to this anchoring issue that we find in the civil practice? And the solution is, it simply says, you know what, counsel can argue to the jury the amount that they think should be awarded to the plaintiff, but it's not to be done until near the end of the case when closing arguments start, and that's because at that phase of the trial, all the evidence is in. So it confines the lawyers, both plaintiff and defense counsel, to argue about the evidence that's before the jury rather than things that are extraneous or irrelevant or designed to inflame the jury in a way that's unfair. I want to be very clear, though, that this provision does not place any limit on the jury's discretion to award that which they think is appropriate to give full and fair compensation to the jury. Rather, Senate Bill 68 protects this jury's impartial decision-making from irrelevant and untimely and improper arguments by either counsel or any lawyer in the courtroom, allowing the jury to do what they're supposed to do, which is render a fair and impartial verdict. Section 2 of the bill, beginning on line 52, addresses the few provisions that are designed to make our civil justice system more efficient and lowering the unnecessary litigation cost prior to the beginning of a trial. There's 3 basic concepts that you'll find in Section 2. And they all deal with the procedure, that is the process by which lawsuits are brought and managed by the court going forward, heading into ultimately a trial. The first deals with a motion to dismiss. Well, the problem is, let's say, for example, that John F. Kennedy gets sued, but I'm being sued as the 35th President of the United States. Well, I'm John F. Kennedy, but I'm not the 35th President of the United States. That's a different John F. Kennedy. But under our current system, I've got to hire a lawyer, file an answer, and potentially have to get engaged in the discovery process, when in fact I'm not the right guy that ought to have even been sued. So what this says is, this proposal in Section 2, is that a defendant ought to be able to file a motion to dismiss. Hey, Judge, look at this from this particular aspect, regardless of the facts, because I am not the proper defendant. And while the court is considering that, I shouldn't have to be engaged in expensive discovery while the court is making that decision. So the solution is that this bill would allow a defendant to file a motion to dismiss, and it encourages the judge to rule on the motion to dismiss before we get into the expensive discovery phase that I shouldn't have to be engaged in. It's fair and it's efficient for everybody involved. It is also an inappropriate usage of the defendant's and the court's times and resources to have to require this other process that we have now when, in fact, many times, sometimes, the wrong defendant has been named and is not the proper party. Further, I would tell you this provision should deter frivolous lawsuits that often rack up unnecessary legal fees prior to the judge's decision on the motion to dismiss. The second aspect of this section deals with something called a motion for more definite statement. Sometimes lawyers plead things in a way that's vague and ambiguous. Not saying it's always intentional, but sometimes that's just the case. And it can be pled so vague and so ambiguously that the other side doesn't even know how to answer. And the proposed change here is to simply allow the defendant to move for a more definite statement. Basically, clarify the ambiguity, and then I will respond. That is a far more efficient way and fair to the parties to get to the bottom of what the issues are before hopefully engaging in wasteful discovery. The third aspect of this section deals with a stay of discovery while a motion to dismiss has been filed. And the problem is the defendant, again, unnecessarily being drug into the discovery process while he or she is waiting on the motion to be ruled on by the court. And this simply allows for a stay of discovery until that motion is ruled on. You'll see on line 99, section 3, this deals with something called the voluntary dismissal rule. The problem is that plaintiffs currently have an option to dismiss their case without prejudice all the way up until the time the jury is picked and after the opening statements have been made and before the first witness is called. This standard unfairly gives the plaintiff an ability to refile or cherry pick a more favorable jurisdiction, a more favorable venue, and after the defense has engaged in all of the expensive process, only to have the case dismissed. Now, what do I mean by that? So, if you're a defendant, a plaintiff files a lawsuit, you get named in the lawsuit, you get served by the sheriff, you go hire a lawyer, the lawyer files an answer, you engage in discovery, which may go on many, many months, which may be very expensive. At the end of that process, there are motions to be filed. You probably had your deposition taken, and on the heels of that, you get a trial notice, you get a court date, you and your lawyer get ready, you go to court. All the while, this is expensive and very taxing on the parties. The jurors show up, your lawyer picks a jury, 12 members are in the box, the plaintiff makes an opening statement, the defendant makes his opening statement or her opening statement, and then the plaintiff says, I think I'll dismiss the case. The defendant doesn't get that option, but the plaintiff does. And I think you get the point of why exceedingly unfair that is. What this proposal does is says that the plaintiff can file and dismiss under the protection of that rule, dismiss without prejudice, but only do so after the answer has been filed plus 60 days. That gives a fair amount of time for the defendant to engage, the plaintiff to engage in discovery to make sure they've got the right person in case there's a question there. Again, just a simple rebalancing of how this all works. On line 124, section 4 addresses the problem of attorney's fees being doubly recovered by attorneys. Well, you may wonder, well, how is that possible? Well, right now in our current law, the general rule is, of course, in America that everybody pays their own way. They pay their own attorney, win, lose, or draw. But we have multiple statutes on the books that allow, under certain circumstances, for the other side to have to pay your attorney's fees, or you to have to pay the other side's attorney's fees. But the problem is, there's not a limitation on the utilizing of those statutes, such that some crafty lawyers have asked for reimbursement of attorney's fees multiple times under different statutes, and they get double recovery of attorney's fees. Well, that doesn't make sense to anyone. Unfortunately, the law is not clear that that shouldn't happen. And this bill simply addresses that and says no double recovery. But when appropriate under the statutes that we have, yes, attorney's fees can be recovered, but not 2 or 3 times for the same action. Section 5 begins on line 140, which addresses the ability of a jury to be made aware of a plaintiff's non-use of a seatbelt. Well, the problem is, right now, if we have a lawsuit and a plaintiff's involved and there are bodily injuries involved, the jury never learns if the plaintiff was wearing their seatbelt. So what's wrong with that? Well, wouldn't it be fair? Wouldn't it just make sense for the jury to know, in fact, was the plaintiff wearing the seatbelt, or did they consciously make a decision to not do something that could have protected them, could have provided more safety, could have availed themselves of the safety mechanisms in the car? Well, of course. And then the one that most everybody says when I talk to them about this, and many of y'all have expressed the same thing, is, wait a minute, isn't there a law that says you have to wear your seatbelt? And the answer is yes. So you're telling me that someone can violate the law, not wear a seatbelt, put themselves at additional risk, and then the jury doesn't know about that while they're asking for money to be awarded? Well, sadly, under the current situation, yes, that is what happens. All this says is that information can go to the jury, and they do with what they think is reasonable and appropriate. Section 6, which begins on line 156, addresses negligent security claims or the liability and responsibility of a property owner when criminal acts of third parties occur on their property. Now, a lot of us have talked about this and referred to this as premises liability, and it is some level of protection that is very much needed, but it focuses on and is narrowed to negligent security claims. The problem, folks, is that businesses of all size, but particularly small businesses, are being held liable for criminal acts of third parties simply because it happened on your property. Whether you own the property or maybe you're a business and you lease the property and you've got a store. But third parties, criminals, come onto your property and engage in conduct that maims, hurts, or kills someone involved in criminal activity, but somehow you get sued. Well, that's happening in Georgia at a dangerous level with alarming results. Businesses, of course, have a duty to take care of their customers and keep them safe. Nothing about this takes away from that. But under our current law, businesses are saddled with an enormous responsibility and in turn are found liable for acts that are totally outside of their control. I'm going to give you a couple examples of what I'm talking about. Racetrack, which is a Georgia company. They've got stores all across the country, but they are a Georgia-based company. Let me tell you about something that just happened a few hundred yards really from where we sit today. The recently closed racetrack on Piedmont, which is a 5-minute walk from here, the store provided fuel, affordable food, and essential products to a once underserved community, and they did so on a 24/7 basis. Racetrack invested substantial time, capital, and resources to build an asset for patrons in downtown Atlanta. Racetrack was determined to invest in this community and consciously made a decision to make substantial investments. And quite frankly, they were excited to have a presence at that location. But in light of some of the incidents occurring near the storefront, Racetrack increased its security, as it should have and did. They spent tens of thousands of dollars to deploy around-the-clock off-duty police officers. They bought expensive mobile alert towers. They put in several versions of state-of-the-art security cameras and then added all the lighting they possibly could. Despite these investments, the store had to close its doors to the public, citing concerns regarding employee safety. However, the efforts to prevent crime from taking place were not enough to prevent Racetrack from being left vulnerable and liable under our current status of the law for crimes that were occurring down the street and even off of their property. Our current law, quite frankly, folks, makes it just about impossible for businesses to achieve an environment to mitigate the impact of the litigation cost. So the solution. At the heart of this issue with our current law is a legal concept that's simple, but it's important. It's called foreseeability. An argument that, quite frankly, business owners are unlikely to win the way things get postured in lawsuits. Senate Bill 68 clarifies the amount of risk associated with any unforeseen acts of a third party by establishing reasonable standards that both plaintiffs and owners can rely on, providing clear guidelines on how to ensure the safety of all their patrons. Let me walk you through just quickly some of the provisions in this section. Section 51-351 talks about the invitee standard. And the law recognizes 3 levels of someone and their status as they come onto someone else's property, with invitees, licensees, and trespassers. You'll see in that section of the invitee section, it has the highest legal obligation, and that still remains here, consistent with longstanding law. You'll see the language in 51-352 regarding licensees and when a licensee could sue a property owner, and then also when a trespasser could sue for negligent security. These provisions set the standards that the plaintiff must prove in order for someone to be held liable. There's also a provision you'll see near the end of this section that deals exclusively and examines with the liability of a security contractor. That is, yes, someone or a company that the property owner or the business owner hires to provide additional security. And that section sets forth when a security contractor assumes the responsibility and undertakes a duty to invitees or licensees to keep all or part of a premises of an owner or occupier safe from wrongful conduct of third persons. That's set out specifically in the bill. Hiring security in these circumstances simply holds the security contractor to the same standards that we talked about that are placed on an owner. And logically, of course, the contractor should not be held to a greater standard than that we put on owners. Section 7, only 2 more to go. Y'all hang with me, thank you. Beginning on lines 343, Section 7 addresses how special damages are presented to the jury. Y'all remember at the top of my comments when I talked about the different types of damages, general damages and special damages. Those special damages are those that you can use a calculator to get to the exact amount. Think in terms of the amount needed to reimburse the plaintiff. General damages deal with pain and suffering, which are not calculable with a calculator, but as I said, are left to the enlightened conscience of a jury. It's important to note that Senate Bill 68 deals only with the special damages, not the non-economic damages, not pain and suffering. What we are currently seeing with jury awards across the state is a problem opportunity. This opportunity stems from the way that medical care providers bill, invoice, and get paid. The process of medical billing, as you probably know, is almost completely governed by federal law. And in those cases where a medical care provider provides services to a plaintiff, there's a rack rate and a retail rate for the medical treatment, and then there's the contract rate. That is the rate that that a medical insurance provider has contracted with your medical insurance company. Think Blue Cross Blue Shield, for example. So we've got two rates. You've got the rack rate, the retail rate, and then you've got the previously negotiated rate. Let me give you an example. Let's say, and this is why this issue, this difference in billing becomes important and why we have to change it in how this information is presented to the jury. Let's talk about plaintiff number one, who is someone without medical insurance. We'll call him Mr. Uninsured. He gets a bill, he's in a wreck, and let's assume that liability is clear. It's not his fault. The person that hit him needs to pay, and he needs to be reimbursed. So he's going to get medical treatment, and let's assume that the rack rate for all the treatment he gets is $100,000, including his co-pays and all that would go into that. So he has to pay the $100,000 to fully satisfy the bill. His claim to the jury is and should be $100,000, so that at the end of the trial, with the $100,000 award, he's fully compensated for his loss. That's what you see here. That's the rack rate. Remember, he should be reimbursed for every dollar that he needs to be reimbursed, but not $1 more than that, because that would be an overpayment. Well, let's talk about plaintiff number two. Well, she has medical insurance. Let's call her Mrs. Insured. She gets a bill for $100,000, but the only amount that needs to be paid to her to reimburse her is what? It's the amount of money that is actually owed to the medical care provider. Let's say the hospital. And in the example on the board by me and on the board behind us, you'll see that the total amount needed to fully reimburse her is the $5,000 that she may be out in copays or other expenses and costs, plus the $20,000 that needs to go to the medical care provider. At that point, that $25,000 amount that she is reimbursed by the jury fully compensates her for her special damages. But the problem is, Mrs. Insured and her lawyer get to go to court and present the bill with the $100,000 price tag. And the jury is not told or able to learn that the real amount she needs to be paid or compensated to be fully reimbursed is only $25,000. So you're wondering, what about all that green on the board? What about that $75,000? Who gets that? Well, she and her lawyer do. It's over and above the amount needed to fully pay for all her medical expenses. Now remember, this has nothing to do with the claim she will also make and be awarded for pain and suffering. This is just the reimbursement portion. But under our current system, the jury hears $100,000, so they award $100,000. She and her lawyer get the $25,000 to fully compensate. They get an extra $75,000, and who pays for it? All of us. All of Georgians pay for that, even though it's not an amount needed or warranted or fair to be compensated. So, let me give you one other idea of way to think about just how imbalanced this is. Let's take an example out of the courtroom. Let's say that you have a little fender bender, whether it's dealing with somebody else. Nobody's hurt. But you take it down to the body shop and they tell you, that's about $2,500 to put a new bumper on. And you say, well, how about giving me an invoice that says $10,000? Well, wait a minute, it's only a $2,500 bumper installed. Yeah, but I want an invoice for $10,000 so I can submit a $10,000 bill to my insurance company. What would we call that? Yep, that's called insurance fraud. That's called insurance fraud. But the current system we have with medical bills allows the direct analogy of asking for more than is actually owed to be fully compensated. So the solution that we've got in this bill, and is a little different from what was originally in the bill, and I'm going to compliment the senator from the 50th who has an amendment that's been offered. And I'm going to let him speak to the amendment, but I will tell you that I am in support of the amendment. I think it is an appropriate landing spot. I will tell you Governor Kemp supports the amendment that's being offered. I'm going to try to push on. I see the red light, Mr. President. I'm going to try to push on and get through this very quickly. I'm going to speak fast. The last section is Section 8, which is line 390, which simply deals with that practice of bifurcation. As I told you at the top of my remarks, every plaintiff has to prove that there's liability of the defendant and the amount of damages. There ought to be circumstances where the defendant can say, let's make a determination of liability before the jury hears issues of damages. This rule change simply says that if either party, the plaintiff or the defendant, wants to do that, they get to do that. I will tell you that there are lots of letters on your desk. The NFIB is asking you to support this, the Community Bankers Association, the Georgia Mining Association, the Cobb Chamber, the Georgia Food and Industry Association, the Builders, Owners, and Managers Association, Uber, the Georgia Independent Insurance Agents, the Georgia Hospital Association, the Associated Builders and Contractors of Georgia, the Georgia Chamber of Commerce, the Georgians for Lawsuit Reform, the Urban Ag Council, the farmers of our state, the Georgia Hotel and Lodging Association, the Georgia Retailers Association, the Georgia Restaurant Association, and the ACCG are all asking you as a broad-based example of why this bill is so desperately needed. I will tell you finally that this bill is a product of a lot of work and good faith negotiations that the governor's office is engaged in with so many various constituencies. This is good for the hardworking folks of Georgia. Let's do the right thing by them. Let's pass this bill. I agree with the amendment. Let's pass this bill, that amendment, and otherwise, that's all. Let's send it to the House and give Georgians an opportunity to hope for a better day when it comes to the tort reform status of the state of Georgia. Mr. President, thank you for the additional time, and I'll be happy to answer any questions.
You do have one question. I recognize the senator from, oh, you want to speak to it? Okay, I'm sorry. Recognize the senator from the 21st.
Thank you, Senator Yield.
Yes, I do.
First, thank you for all your hard work on this, Mr. Pro Tem, and working with the Lieutenant Governor's office. This is a great bill. But I do have one question. If you could just go back to Section 4 and talk about the payments to the attorneys and the court costs and expenses. I just want to get some clarification on that. You didn't say loser pays. You didn't use that word, but you did say that in some cases the plaintiff attorney may have to pay the defendant's attorney fees. I think I heard you say that there are some cases of that. Could you explain that a little bit?
Sure, and so we've got 3 or 4 fee shifting mechanism statutes in Georgia where, depending upon either the conduct of the parties pre-litigation or the conduct of the parties and the lawyers pending litigation, and then 2 other statutes that can come into play, and actually a few others, where one can ask that you get reimbursed your attorney's fees. Under those circumstances, a party can have the other side pay what they've had to pay their lawyer. So that's okay. We're not changing any of that. What we're saying is, wait a minute, if you're entitled to have your lawyer fees paid, you ought not to be entitled to have your lawyer paid twice the amount of his bill or 3 times the amount of his bill. That's all it does.
Okay. Thank you, sir.
Yes, sir.
Recognize the senator from the 41st.
Thank you, Mr. President. This is Senator Yield.
I do.
Thank you. Would you look at Section 5 regarding the seatbelt provisions that you spoke about?
Yes.
So can you tell me, in the event of a car accident, if there are, say, minor damages, how would an occupant prove that they were wearing a seatbelt at the time?
Well, very simple. It begins with the plaintiff's testimony. They will testify under oath, either through a verified petition in their complaint that they were wearing their seatbelt. They can give an affidavit saying that. They can state that in their deposition. And there's also other mechanisms that can be used, but that's the beginning point, that they will say that they were wearing their seatbelt.
Do you further yield?
Sure.
So if the defendant says, no, the plaintiff was not wearing the seatbelt, because for many of us, when we get in an accident, one of the first things we do is we check, we unbuckle our seatbelt, make sure the kids are okay, we get out, look at the damage. So if the defendant says, no, you weren't wearing your seatbelt, assigned, me saying that I did it doesn't matter. So again, how does one prove that you were wearing a seatbelt without having to go through a lot of rigmarole?
Senator, it's the same way everything in court gets proven. That's an issue of fact. If the plaintiff says he or she was wearing her seatbelt and the defendant has reason to believe or evidence that they were not wearing their seatbelt, that's no different than when the plaintiff says the light was green when I went through the intersection and the defendant says, no, it was red. That's what jurors do every day in every lawsuit. They resolve those facts of factual dispute.
Thank you.
Recognize the Senator from the 16th.
Senator Hill?
I do.
Yes, sir. Thank you. Excellent job, sir, in presentation. Going back to seatbelts, because of last year there was an issue. As I'm reading in line 143 and also in 152, it says any seat. So this actually will pick up the rear seats, which has been an issue with some of the services like Uber and Lyft, where the passenger in the back was not required to wear a seatbelt under our old law. This would require the seatbelts in the rear, is how I'm reading this. Am I correct, sir?
I would answer it this way, Senator, to make sure, because I don't want to stray far afield from the specifics. But if you look on line 143, that language is not actually changed. That's original in the statute now. That the failure of an occupant or motor vehicle to wear a seatbelt in any seat of a motor vehicle, that's in current code now. And I think to your point is it remains unchanged. Yes, sir.
Okay. Okay. Thank you, sir.
Yes, sir.
Recognize the Senator from the 13th.
Senator Yield?
I do.
Senator, in dealing and asking with car dealers, whatever, I checked and I asked that question you were asked just a minute ago. Isn't it true that the ECM, the electronic control module, will verify the seatbelt and help in that instance?
Senator, I think you're exactly right, and I think that's the technical name maybe for what we think of as the black box, and you're absolutely right. There's multiple ways. That's probably one of the best ways to do it. One of the other ways that's very common is if an occupant is wearing their seatbelt and there's a crash, the medical reports will obviously, or many times, show bruising in the area where the seatbelt is. Many logical, common sense ways, in fact, to prove whether or not the seatbelt was worn or not worn at the time. And thank you. I appreciate the question.
Thank you, Senator.
You have no further questions, Senator.
Thank you, Mr. President. I look forward to speaking to you, hopefully not as long when the time comes to conclude the debate. But in the meantime, I appreciate your consideration of this very, very important opportunity for us to improve the lives of Georgians. Thank you.
Thank you, Senator. Okay, we have amendment number 1. We're going to go ahead and read amendment number 1. I'm going to let the Senator from the 50th speak to that amendment, and then everyone who's signed up to speak, we'll let you have that chance after the Senator from the 50th presents his amendment. Secretary, read the caption.
Mr. President, Senator Hatchett of the 50th, Kennedy of the 18th, and Strickland of the 42nd offer the following amendment number 1 to amend the Senate Committee on Judiciary Substitute to Senate Bill 68 by replacing line 10 with the following. Actions to provide for the recovery of special damages for medical and healthcare expenses and personal injury and wrongful death cases, to provide for construction, to provide for definitions, and for other purposes. That completes the order, Mr. President.
Recognize the Senator from the 50th.
Thank you, Mr. President. I rise today to bring you Amendment 1 to Senate Bill 68. A lot has been said about Senate Bill 68, some true, some not true, but the version of Senate Bill 68 and this amendment that's before you today is the result of a lot of hard work and compromise. I want to commend Governor Brian Kemp and his staff for all the hard work that they've put in to this bill and their commitment to work with the General Assembly. Throughout this process, and to the Pro Tem's presentation today, a lot has been said about truth. So I'll just go ahead and address the elephant in the room, and we'll talk about truth. I'm an attorney. Some of you may not know that, but I'm an attorney. I'm a plaintiff's attorney. And for a guy like me who really enjoys helping people, it's my dream job. To me, plaintiff's attorneys are the voice for the little guy. They're the guys who stop companies from dumping waste or selling poisoning products that make your entire community sick. We're who make sure corners aren't cut for profits when they design your child's car seat. We're the voice of the everyday man trying to hold big, powerful companies responsible when they decide to overlook your safety and health just to make more money. I'm sure you've seen Aaron Brockovich or Dark Waters. They're true stories. But somewhere along the lines, with some campaigning, some people forgot how valuable your constitutional right to a jury is. And that right is your voice against corruption and wrongdoing. So, now that the elephant has been addressed, I am an attorney. But I'm also a conservative constitutionalist that thinks constitutional rights should not be whittled down in exchange for elusive, uncommitted promises of lower premiums. However, this amendment is a testament to the legislative process working as it should, through thoughtful debate, compromise, and a shared commitment to doing what's right for Georgia. Over the past few weeks, there's been immense pressure from all sides of this debate. I know many of you have felt it. Calls, emails, and strong opinions from folks on both sides who, while passionate, may not fully grasp the complexities of this bill or the complexities of this process. But that's what my constituents elected me to do. I'm the person they've made responsible for reading it, analyzing it, and fighting against parts that I think are wrong and supporting parts that I think are right. And last night, through the hard work of my colleagues, I want to thank the Senator from the 42nd, President Pro Tem, Lieutenant Governor, the Governor and his staff, we were able to thread the needle. We removed some problematic elements from the previous law, the previous bill, and we brought forward an amendment that reflects fairness and balance between our beliefs. So what this amendment does is, as the Pro Tem eloquently described, this is a medical bill. And right now, when you present a medical bill to a jury, all they see is this top dollar amount. And one of the most common questions that a jury writes to a judge when they're deliberating is, Judge, does the plaintiff have health insurance? They want to know. And the only thing the judge can say back to them was, I can't comment on that. You have all the evidence that you're allowed to consider. So that's how it's been. What the proposal now is, well, let's just show them the yellow part. Let's just show them that. And there are some issues with that when you're talking about people who are uninsured. Maybe they'll get treated differently. People that have better insurance plans, maybe they'll get treated differently. And this concept is so old and ingrained in the law that a solution, well, it's got to be complex, right? To fight this complex issue, how do we get the truth to the jury? It's got to be complex. Well, luckily, there are smart people on both sides, and what we've come up with is tell the jury the truth. If the jury wants to know if the plaintiff has insurance, show them. If the jury wants to know how much the bill was, show them. And so what this bill says is that instead of redacting what insurance paid, redacting what the plaintiff actually paid, you're going to show the jury the truth. There have been constitutional questions about this bill and about the provisions. I don't think anyone can say it is unconstitutional to tell the jury the truth. And that's what this amendment does. and it is fair on both sides. There have been allegations that anyone who dares to change this bill will face a primary opponent. Well, my job is to create good law. This amendment achieves the governor's original goals while making common sense adjustments that strengthen the bill, and I'm happy to share that's what we did. This is a friendly amendment born from all of us coming together at the table and doing good policy. Mr. President, I'll close and then I'll yield for questions. I am an injury attorney, and contrary to some rhetoric floating around, we do hate frivolous lawsuits. They cheapen our work, they undermine our mission to hold wrongdoers accountable and make our communities safer for our families. No one wants businesses crushed by baseless claims. At the same time, I believe no one wants corporations operating unchecked. There are bad seeds in business, and there are bad seeds in plaintiffs' lawyers. But good businesses are the backbone of Georgia, and plaintiffs' lawyers are the checks and balances we need. This amendment helps create that balance. Georgia thrives when both responsible businesses and vigilant advocates coexist. So I urge you, don't let the loudest voices cloud your judgment. This amendment is a product of careful thought, collaboration, and respect for every Georgian. This bill isn't perfect, no bill is, but this amendment makes it better, and I'm happy to yield for questions.
You have no questions, Senator.
Thank you, Your Honor, or thank you, Mr. President. I yield the will.
All right, so we've got a second amendment that's just arrived, so we'll go ahead and address that amendment, and then we'll go to the floor debate. Secretary, read amendment number 2.
Mr. President, Senator Islam Parks VII and others offer the following amendment number 2 to amend the Senate Judiciary Committee substitute of Senate Bill 68 by inserting after line 414 the following. Chapter 1 of Title 33 of the Official Code of Georgia Annotated related to general provisions relative to insurance is amended by adding a new code section and for other purposes. That completes the order, Mr. President.
Recognize the senator from the 7th. Speak to the amendment.
Thank you, Mr. President. We've heard a lot about Senate Bill 68, a bill that claims to bring down insurance costs, but in reality does nothing of the sort. Nothing in this bill requires a single penny of premium reductions. Nothing freezes rates. Nothing stops insurance companies from hiking up prices whenever they want. What this bill really does is hand more power to the insurance industry, an industry that made a record $90 billion in profits last year and is projected to clear $120 billion this year. And the justification for this bill? A so-called crisis that doesn't even exist. The governor himself has said Georgia is the #1 state to do business, the #1 place to do business for 11 straight years. 11 years. That is not a crisis. And what we're seeing here isn't about fixing a broken system. It's about creating a manufactured crisis to justify stripping away consumer protections and handing even more power to billion-dollar insurance corporations. Meanwhile, Georgia families, our constituents, are being crushed by rising insurance costs. And if we don't put real guardrails in place, we know exactly what's going to happen. We've seen it before. Florida has passed tort reform legislation, and their insurance rates have skyrocketed. Auto insurance up 23%, home insurance up 177%, overall premiums up 37%. That's what happens when you hand power to billion-dollar corporations and expect them to suddenly start looking out for working people. Spoiler alert, they won't. And I take this personally. My mom was the breadwinner in my family, and she worked a manual job. She was an order puller at a warehouse where she picked up boxes and put them on trucks for 14 years, and she injured her back. Workman's comp was supposed to help, but they only wanted to pay part of her care. So what do? My family had to fight, and we had to sue the insurance company just to get what she was owed. That was our right. That right made my mother and our family whole again. But under bills like this, families like mine will lose rights while corporations gain even more power. And this is why I'm offering an amendment, a real solution that actually puts Georgia families first. My amendment does one simple thing. It ensures that insurance premiums will not rise any faster than the rate of inflation. That's it. That is what real reform looks like. And if you're serious about making insurance more affordable, this amendment is the bare minimum. And this is the rationale for the entire bill. But if it's not adopted, if any member votes against it, then let's call this bill what it is: a massive giveaway to an industry that does not need another handout. So I ask my colleagues, are you here to protect the people who elected you, or are you here to protect insurance company profits? The choice is clear. Vote yes on this amendment. Thank you, and I yield the well.
All right, so that's amendment number 2. Senator spoken for her amendment. I recognize Senator from the 1st speak to the underlying bill.
Thank you, Mr. President. Lawsuit abuse is decreasing patients' access to health care, driving up health care costs, and causing doctors to retire early or leaving Georgia altogether, compromising patient health. Right now, doctors are leaving the state due to high malpractice insurance. Hospitals have closed, mostly in rural areas. 66% of counties lack maternal health services, and over $1.56 billion in lawsuit costs have been passed on to Georgia patients through increasing insurance premiums. But the provisions of this bill are not a gift to insurance companies and big corporations. They are aimed at leveling the playing field for every hardworking Georgian in our civil courts asserting their constitutional rights, reversing the current system that primarily benefits only plaintiffs and their attorneys. This is just making it fair. Our civil justice system has been leveraged against those accused of wrongdoing to extract higher verdicts, settlements, and fees. Nowhere has this pain been more felt acutely or chronically than our physicians, hospitals, healthcare workers, and patients. The current state of our medical liability system makes it difficult to recruit and retain physicians in our state, deprives our citizens of important access to critical health services, and drives up the cost of health care for every single Georgian. I'd like to go over just a few of the specific pieces of the bill that can help balance our judicial systems in Georgia, and especially important for our doctors, hospitals, and patients. Anchoring prohibits attorneys from suggesting arbitrary benchmarks for damages. Trial bifurcation separates liability and damages into separate trials to ensure fair outcomes, but it's still the same jury. Truth in damages, using actual medical cost rather than inflated bills in presentation of the damages. Imagine that, actual costs. It's not really complex. Procedural fairness extends response to the deadlines to prevent unfair legal leverage. Curbing double recovery of fees. Ending shopping of venues and voluntary dismissals. It stops the abuse of legal loopholes to manipulate case venues and timeliness. You all received letters on your desk a few weeks ago from MAG, Medical Association Georgia, Georgia Alliance Community Hospitals, Emory, Curie Insurance, and today, Georgia Hospital Association. The passage of, and let me just read one little excerpt of that letter. The passage of SB 68 will have a profound impact on patient access to care by lowering malpractice premiums, reducing legal burdens on healthcare providers. These reforms will help retain and attract medical professionals, especially in high-risk specialties such as obstetrics and surgery. This means more doctors and better access to life-saving treatments for patients across the state, particularly in rural and underserved areas where health care shortages are more critical. But let me just say, though we've seen the facts by Commissioner of Insurance John King, that your car insurance, home insurance, rental insurance, property and business insurance, and on have gone up crazily. But it's the provisions in this bill that are greatly needed by the Georgia healthcare community, and most importantly, by Georgia patients. Thank you.
Thank you, Senator. We have one more late arriving amendment, Amendment 2A. Secretary, read the amendment.
Mr. President, Senator Islam Parks the 7th offers the following Amendment 2A to amend Amendment 2 to Senate Bill 68 by inserting before line 1 the following: to amend LC 492233-ECS by replacing line 1 with to amend Title 9, 33, 40, and 51 of the Official Code of Georgia annotated related to civil and for other purposes. That completes the order, Mr. President.
Senator from the 7th, would you like to speak to your amendment? She waves. It's just a technical correction anyways. Recognize the senator from the 4th.
Thank you, Mr. President. Every session, we have a major bill that keeps me awake at night. Last year it was the CON bill. This year it's the tort reform bill, Senate Bill 68. Do I believe in tort reform? Yes, I believe in tort reform. I believe in it just like mom and apple pie. I'm a CPA. I look at hundreds of financial statements each year, and I look at the devastation of insurance costs that our clients and your friends are experiencing. This major tort reform bill has been caused by the bad actors that you see on TV and as you ride up and down the road. Bad actors, also referred to as bad apples. The frivolous lawsuits and sayings like, have a wreck, get a check, by Mike Costello down in my area, or they offered $20,000 and we got $120 million by Morgan & Morgan in Atlanta. These are the type of attorneys that have made all attorneys look bad. These sayings and signs get in people's heads, and it actually brainwashes them to think that the frivolous lawsuits are the right way to go. I have worked with hundreds of attorneys in my professional life that have high morals and high ethics. We have several Republican trial lawyers in our body that have been working very hard on this bill with the governor's office. I have the utmost respect for you, Senator from 50th, Senator from 42nd, and Senator from the 19th. However, my biggest phrase in my professional life and my Senate life is working together works. When we work together, we all win. I am happy to vote green today on Senate Bill 68. Thank you.
Senators yielded. Senators from the 20th.
Thank you, Mr. President. I rise to speak against the amendments from the senator from the 7th and to try to tell you about the industry that I work in, that I'm proud to work in, and defend against some of what she said. This bill that we have today, Senate Bill 68, is not to line the pockets of insurance companies, as she says. Insurance companies come to the aid of people when they're at their worst possible moment, whether they've suffered a hurricane or a natural disaster, if they've been in a car wreck, if they've had their house is burnt down. And insurance companies, of course, are in the business to make money. And if they don't make money, they're not going to have the reserves on hand to come to the aid of their policyholders. The system serves Georgians well. It serves Americans well. We can't always be looking to government to take care of us in the event we have a natural disaster or a problem, we look to the insurance companies in the private sector to do that, and it does it a whole lot more efficiently and cost effectively and better, in my opinion. Certainly insurance companies make money. As I said earlier, they have to make money to stay in business and be there when we need them. The problem is with the way our laws are structured and the lawsuit abuse that has crept into Georgia over the past decade, insurance companies are not making money in Georgia. They're making money nationally, but they're not making money in Georgia. And they can decide where they want to deploy their capital and where they want to do business, and they're going to go to states where they can make a better return on equity. We don't want to become like California, where the insurance companies have left the state because of lack of profitability, and people are left out there without homeowners insurance, and then they have a wildfire and there's nobody to help them. And they're looking to the government and the taxpayers to bail them out, and it's just not going to happen. In Georgia, the profitability for insurance companies over the past decade, the statistics I have are from 2013 to 2022, is actually negative. They've lost money in Georgia over those 10 years on commercial auto, personal auto, products liability, and medical professional liability lines. I started my insurance agency. I'm an independent insurance agent. I deal with my community and have customers throughout Georgia. I started my business in 1996. In April, I will have been in business for 30 years. I have never seen the insurance market be so difficult and so tight and so hard to place business. Some carriers have exited Georgia altogether, but what we're seeing more commonly is carriers deciding not to write certain lines of business because their losses have been so significant in those lines of business. We see carriers exiting certain geographic areas of our state and not willing to insure homes in certain parts of our state or businesses in certain parts of our state. We are looking to try to balance the playing field or balance the civil justice system to make Georgia more competitive and make the playing field fair. We know people need to be able to recover if they've been injured due to negligence of somebody else. This bill does not prevent that. It just makes it more fair to both parties so that we have a competitive insurance environment. Carriers will be competing for people's business, come back into the market, and stabilize the rise in premiums and stabilize the cost of insurance and hopefully lower the cost of insurance. Just a few more statistics for product liability profitability for 10 years from 2013 to 2022. In Georgia, the insurance companies actually had a negative return on net worth of 1.9%. So they lost money on products liability. Nationwide, they made 5.2% return on equity, which is way below what most industries make on return on equity, but they at least did make 5.2%. On property and casualty for the entire industry, nationwide they made 7.7% return on equity. The average for the Fortune 500 companies is 13.8%. So the insurance company's making 7.7%, and they're taking a lot of risks. They actually could put their money in basically a EFT or something and make some sort of investment with very little risk and make more than they're making by selling insurance. Let me see, I had some. So the 10-year period, 2013 to 2022, the average profitability in Georgia across all property and casualty lines has been less than the U.S. average. So in Georgia, the average profitability or return on equity, 3.5% on all lines, whereas in the U.S. average is 7.1%. So if you're a business person, are you going to continue to deploy your capital in Georgia and make half the return on equity that you can make in other states? No, you're going to leave Georgia, and that's what we've seen happening. Personal auto insurance, which everyone in here has and buys, and you're seeing your premiums go up, and you think the insurance companies are making a killing off of you and taking advantage of you, and the big bad insurance companies. In Georgia, they've also actually lost 3.7% in the last 10 decades. So it's a losing proposition for the insurance companies, and our insurance commissioners got the difficult job of trying to balance approving rate increases, knowing that it's been unprofitable for the companies in Georgia. He's trying to balance and keep rate increases as low as he can, but he also has to make sure there's enough surplus in these companies, and it is not so unprofitable that the companies go out of business and leave the policyholders holding the bag. So that was personal auto. On business auto, it's even worse, a loss of 4.4%. On medical professional liability, it's a loss. So for people to come to the well and tell you that this bill is to line the pockets of insurance companies and allow companies that are profitable to get even richer is not true for Georgia insurance, the Georgia insurance industry. And I just felt compelled to come to the well and defend the business, defend the industry that I'm so proud to work in. And I'm always happy when we're able to help our customers in their worst time of need. So, Mr. President, if there are any questions, I'll be happy to try to answer them. Otherwise, I would yield the well. And again, I oppose the amendments from the senator from the 7th.
You do have a couple questions, Senator. I recognize you waive. Okay. I recognize the senator from the 37th.
Thank you, Mr. President. This is Jillian Yield.
Yes, sir.
As an insurance agent, you've been in this for a number of years as a career?
Almost 30, yes, sir.
Yes, sir. I find it an overall blessing to have folks that are insured, to have the confidence that insurance provides. I mean, is it your assessment that healthy insurance companies actually serve people in our state?
Yes, I feel strongly about that. I'm real proud of my profession.
So if we're in a circumstance where premium increases are locked in by statute, and there's disasters, there's things that insurance needs to step in and support, we lock them in as Amendment 2 proposes, does it not leave insurance companies in a circumstance they can't serve customers anymore if we're locking them in by statute of what they can charge as premiums?
I think you're right, Senator, and I think we would find ourselves like the state of California has found itself, the residents there. Florida was going down that same path. You had almost no carriers that were willing to write homeowners insurance anymore. Down there, I think the state fund insured over half the population in Georgia, in Florida. They've made some changes to their statutes that we are trying to do here, some similar things, and it's already kind of turned that situation around. So I'm all for people being able to recover if they've been injured due to negligence of somebody. This Senate Bill 68 does not prevent that. It just it eliminates frivolous lawsuits, balances the playing field, and allows insurance to come back in and compete for your business, which should drive down premiums and is fair to all concerned, I think, Senator.
And isn't it true that Senate Bill 2, in spite of, again, the Amendment 2, in spite of a passionate presentation by the author, is just not going to create a healthy insurance environment that can serve people who are in need? If we pass this, it undermines healthy insurance for folks who are truly in need. Isn't that true?
I couldn't agree more. Thank you, Senator, and I'll yield the well.
Senator from the 7th, would you like to come speak to your Amendment 2A?
Thank you, Mr. President. Amendment 2A simply cleans up a drafting error in Amendment 2. The substance does not change. This amendment is simple. It says, insurance rates will not rise faster than inflation to protect our constituents' wallets and ensure that greed for profits can't unduly harm people. I yield the well. Thank you.
Recognize the senator from the 2nd to speak to the bill.
Thank you, Mr. President. Colleagues, this morning I will be brief. And I looked through the list of letters on my desk this morning, and each of you have received the same list of letters. And I wore my glasses yesterday, and Mr. President, I didn't wear them today, but maybe I should have, because I might be missing something. And as I flipped through and I did a roll call of everybody that had submitted a letter, I noticed I didn't have one from one insurance company. I didn't have a letter from any insurance companies basically outlining that upon the passage of this bill, we could expect premium reductions and premiums to decrease. And as I thought about it, if this is affecting everybody, they have a vested interest in it, because even the folks who don't do business in Georgia but would like to come to Georgia would have a vested interest, and then maybe they would have provided a letter. Because the letter would have been something that we could have held at this well, maybe this session, maybe the next session, maybe 3 sessions after that, and said, but on February 21st, 2025, this is what you said. But the problem is you can't hold them accountable for anything that they said because they didn't say anything. And that's what I'm looking for. My constituents, business owners, citizens are looking for relief on insurance premiums. But if they don't have a letter where they commit to doing something, then they have no commitment to honor. And I heard a great preacher one time say that in order to hold folks accountable, you got to ask them to be true to what they said on paper. And they haven't said anything on paper about what they intend to do. It's all conjecture about the numbers and how much money they can or cannot make, and the state of Georgia is not profitable, the #1 state to do business. And when I went to Asbury University, I learned what a juxtaposition was. And that is 2 ideas in the same sentence. But there's a vast contradiction. So we're the #1 state to do business. We're also a judicial hellhole. And then we're also losing insurers by the day. But if we're the #1 state to do business and people are coming here to do business, Mr. President, then that means that we have a workforce and an economy that would support businesses to grow, and businesses wouldn't go nowhere where they couldn't be insured. But maybe that's not the issue. Well, Mr. President, I just asked my colleagues to think about what's said on these papers. Everybody is an association or a business owner or directly affected, and I even see the letter from the independent insurance agents. Now, they're just the agents, but they're not the insurance company. Where's the letters from the insurance company, Mr. President? And so as I get ready to close, now y'all know I'm also a Baptist preacher, so I got 3 more closes. Let us not seek the Republican answer or the Democratic answer, but the right answer. Let us not seek to fix the blame for the past. Let us accept our own responsibility for the future, and that was President John F. Kennedy. And the reason I share that is because it is not about anything partisan in this. It is about where are the letters from the insurance companies. Because before you vote on something, I want to be able to have something in writing to make sure that I know what the insurance companies are committing themselves to. Because in the Constitution, we wrote out, the architects of our republic, what we would commit ourselves to do. Life, liberty, pursuit of happiness. We wrote what we would be committing ourselves to. In the state constitution, we wrote what the state of Georgia would be committing ourselves to follow in that constitution. I just ask colleagues, what will the insurance companies produce to commit themselves to so that we can hold them accountable by what they said. But I will encourage you that that's missing this morning. And so in the absence of something, I just have to assume what they will or will not do. And it is my opinion that without having something from them, I can't tell you what they may or may not do. But if they were serious about it, because the other folks that submitted letters are serious about it, they would have put something in writing to tell us how serious they were. And so as I close, again, Dr. King said, in a real sense, all life is interrelated. All men are caught in an inescapable network of mutuality, tied together in a single garment of destiny, because what affects all indirectly. I can never be what I ought to be until you are what you ought to be, and you can never be what you ought to be until I am what I ought to be. And this is the interrelated structure of reality. And until we have documentation and letters from the insurance companies that tell us what they're committing themselves to do, then what we're talking about today is still interconnected and interrelated, because we really don't have an answer for what the folks are asking us about, and that is, how will my premiums go down? And so I leave you with the question. After all that's been said and done today, Mr. President, what will be done to lower premiums? But the insurance companies haven't committed themselves to tell us that. And with that, I yield the well.
The senator has yielded. Recognize the senator from 35th.
Will my premiums go down? Colleagues, I'm here to make a similar statement to my friend from the 50th, and also stating that I'm a lawyer. But unlike my friend from the 50th, I'm a defense lawyer. I've spent the last 15 years of my career defending companies in civil litigation. I've spent a lot of time defending companies against frivolous and fraudulent litigation. Or should I say I've wasted a lot of time defending companies against frivolous litigation. I'm also a small business owner. And my wife and I try to do everything right. And despite that, we've seen our insurance rates increase dramatically. Nearly 30% just this past year. We certainly felt that pain. I understand the pain that Georgians are feeling when they get that insurance bill and there's an increase. I also firmly believe that we need a legal system that is fair and where the playing field is level. I believe that Georgians deserve a legal system that is fair, and I believe that they deserve relief from those high insurance premiums. The problem with this bill, as written, is that this bill does not provide that needed relief. As the senator from the 2nd just pointed out, there is nothing in this bill that provides relief from those sky-high premiums. There's nothing in this bill that provides you relief from increasing insurance rates. And even worse, it will prevent thousands of Georgians who have been legitimately injured or killed from filing lawsuits and suing people who have done them wrong. Now look, I know this bill is going to pass. But what I'm hoping is that my colleagues in the House can truly perfect this bill, because I want to support a bill that will provide me relief. I want to support a bill that will level the playing field when it comes to our civil litigation system. But this bill right now does not do that, which is why I'm voting nay. The reality is that hardworking Georgians, including small business owners all across this state, are being sold a bill of goods that you cannot deliver. For example, the author of the bill talked about insurance rates going down in Florida. But the results have been mixed. As my colleague from the 7th pointed out, insurance premiums have gone up in certain areas. And where they have gone down, they have mostly gone down because they have been heavily subsidized by taxpayers in the state of Georgia. So on one hand, taxpayers have seen relief in some areas of the insurance industry. But on the other hand, their hard-worked tax dollars are being used for insurance company profits so that they can see some relief in their tax bills. It's a sleight of hand. This bill must be improved, and it must be improved in several sections, including premises liability. Democrats have offered a solution in SB 223, and I know that the minority leader will be speaking on that more specifically. But I want to take a moment to talk about the legislative process that we've heard so far. The truth about this process is that while the author has stated that stakeholders were at the table, the fact of the matter is that nearly everything that has been suggested or offered has been rejected, has been ignored, has been disposed with. And the reality is that Democrats, including those who want to see a level playing field in our litigation system, have not been included. I'm going to say that again. Democrats who want to see a level playing field, who want to see insurance premiums go down, who want to see change in our litigation system, have not been included in this process. But despite that, we will keep trying. I also want to speak to the unfortunate circumstances behind this bill. There have been a lot of letters, a lot of emails, a lot of phone calls. We received probably the most letters that I've ever received while I've been here in one day. We've gotten advertisements on social media. We got a massive press conference. My question is, where is that energy on issues that cost this state and hardworking Georgians way more than tort reform? Where's that energy when it comes to expanding Medicaid and making sure that every single Georgian in the state has access to affordable health care? Where's that energy to making sure that we don't have 1 in 5 children living in poverty, 1 in 5 seniors looking for their next meal? Where's that energy when it comes to trying to find affordable health, child care? Where's that energy when it comes to changing the fact that more than 60% of our children are not reading on grade level in 3rd and 4th grade? Because, colleagues, when I think about my businesses, you know what the number one issue is? Workforce. Making sure that we have staff in place so that we can serve our customers and we can turn a profit. Workforce. So when I talk to my employees on why they can't show up to work, you know what they mention? Childcare, housing, healthcare, transportation. Solving these issues would not only bring down costs for every Georgian, it would increase profits for those business owners. Guaranteed, no letters necessary. That's the kind of relief that Georgians deserve. So, colleagues, I'm voting no today in the hope that it encourages the House to improve this bill. But if the House does not improve this bill, Georgians have been sold a dream that will not become a reality. Mr. President, I yield the well.
The senator is yielded. Recognize the senator from the 22nd.
Thank you, Mr. President. I rise in opposition to this bill, but I actually want to try to give a roadmap on how things can actually be improved here, but by actually showing some of the issues with it, dealing specifically with the premises liability section, about the fact that we have, it's not even competing interests, they're actually the same interests. The interest is for businesses to thrive, but at the same time, we want customers and we want our people to be safe. And so the question becomes, what is the best way to kind of achieve that interest? Whether that can be achieved through some type of compromise language, or it can be achieved almost through closing the courthouse doors, which does this community no good. I would argue that right now our current premises liability, which is in this particular bill, completely closes the courthouse doors from people actually being able to bring a suit on third-party wrongdoers. And why do I say that? Because there's a lot in this particular bill that kind of speaks to that. Looking first at our page 10, which deals with one of the ways of being able to prove a third-party claim is if that the person who's bringing the claim can exploit a specific physical condition of the premises. Well, how would you show that? How would you be able to show that the wrongdoer, the robber, the murderer, whatever it is, that he or she actually exploited a specific physical condition of the premises? It's almost impossible for anybody to be able to show that. They're not going to testify. They may not even be around. So how are you going to be able to show that they actually exploited that condition? But then it becomes even more problematic when we look down on line 226 and we see that the reasonable foreseeability, the risk of wrongful conduct on the premises basically must be substantially greater than the general risk of wrongful conduct in the vicinity of the premises. Now, what you're basically saying is if a person is shot, you would have to show that that conduct is substantially greater than what's happening within the community. Well, we just talked about the fact that these things are basically many of these places are high crime areas. So it's not beyond imagination that you're going to have people in those vicinity of the community that has what? Been shot. So you're basically foreclosing the courthouse, because how would you prove that it was actually greater, substantially greater than what actually happens within the vicinity? So if you have a shooting, and then within the vicinity there are shootings, then that shooting would not be substantially greater. And then also, how would you even show what happens within the vicinity? Who are you going to call? Are you going to bring up general crime statistics? How are you even going to be able to show that? You basically are actually foreclosing the courthouse with that type of language. But we're going to go further. Just a few more points right quick. If we look at page 12, where we start saying, we're actually starting on page 11. Notwithstanding code sections 51.351 and 53.1.352, no owner-occupier shall be liable for negligent security arising from an injury sustained by a person not upon the premises of the owner or occupier. This deals with the injury. This actually would talk about somebody being chased off someone's property, a business owner's property, who basically could possibly be liable, and if the injury occurred off the property, there could be no liability. This isn't about duty. This isn't about proof. It says there will be no liability, period, none. So the injury, if it happens off the property, there is literally no liability. So if on the property, if on the premises, place is not safe, there have been no cameras, there hasn't been any opportunity to try to keep the people who are shopping there safe, if they get chased off the premises, and because the injury happens off the premises, this says there is no liability, period, if the injury happens off the premises. Not the wrongdoing, the injury itself. That's what it says. Also, a similar problem with part 3, which deals with the wrongful conduct of a third person, if it happens off of the premises, which directly implicates the Six Flags case, where a person was beaten into a coma because it happened 200 feet off the premises. So those are just some areas of concern within the premises liability piece, and there are a lot more. And I will also address how we can kind of like clean all of that up. But the second part of this is, why would you actually do this from a policy standpoint? From a policy standpoint, why would we try to foreclose the courthouse doors? One of the things that is mentioned many times is, from a policy standpoint, if you don't have this particular legislation, you will have food deserts in high crime areas or poor areas. That has been mentioned many times. You have food deserts in these areas. That would mean that if we looked at states with similar laws, that they do not have food deserts. So I bring you to Alabama and Mississippi. Alabama and Mississippi's laws are actually more strict than the law that we're proposing today. In Alabama, for instance, to be able to prove a claim, you actually have to show that you had similar conduct of 3 prior felonies. So for a person to be able to recover in Alabama, they have to show that on the premises there were 3 prior felonies that took place. That's part of the burden of proof. So naturally, obviously, since they are so strict, there are no food deserts in Alabama. The problem is 16.3% of Alabamans live in food deserts. 150,000 people in Birmingham alone are in a food desert, which is 67% of their population. In Mississippi, for instance, which is similar type of law, they actually passed theirs through statute. Mississippi is a similar type of law. Interesting to know there, 20% of Mississippi residents live in food deserts. So the idea that if you pass these laws that food deserts are going to end just is not accurate, because what goes into food deserts is lack of transportation, poverty issues, and also educational issues. Another reason from a public policy standpoint that we look at this is we talk about runaway juries, which is interesting, because first, we never hear about the juries that don't give anybody any money. They're not runaway. Those are okay. But runaway juries, when we talk about this, is a very interesting term, because we're talking about citizens who are making these determinations, citizens who are actually determining these verdicts. And so here is the scenario that you have to have when you say that these verdicts are so wild and runaway. The scenario is that you have a frivolous claim that goes in front of a jury. First of all, it had to get through a directed verdict and also a motion for summary judgment. But you have this frivolous claim that goes in front of a jury. And who's on these juries? Many times these are people who actually can't get out of jury service. So sometimes they may not have the best job and things of that nature to get out of jury service. So who's on there? So you have these jury members who don't even want to be there. They don't want to even be there. Some of them may be struggling to pay their light bill, struggling to buy groceries. And here they get this case, supposedly, this frivolous nothing case. And here they are sitting there saying, I'm struggling to pay my bills. I'm struggling to pay my grocery bills. I'm struggling to make a living. But you know what I'm going to do today? I'm going to take this frivolous case and make you a millionaire. That's total foolishness. No one's going to be doing that. And not only is it one person, 11 other people are also in on it too. And not only are they in on it, apparently the judge hears these frivolous cases and refuses to direct a verdict. The judge hears these frivolous cases and refuses to do a motion for summary judgment. And then it gets to the jury, and these people are sitting there saying, you know, today I might have trouble even making my light bill, but even though this case is the worst case ever, it's frivolous as all get out, you know what I'm going to do? I'm going to make this person a millionaire. It's foolishness. And what's always interesting is we never talk about what actually triggered these cases. The CVS case and the Six Flags case, where one person was actually shot and another person was beaten into a coma and has long-lasting injuries. We never discussed that. We always just say frivolous, and we always just throw terms out there about that. But actually what's triggered all of this was those 2 cases where people were genuinely injured. But then that brings to my last point, and that is that the author talked about the racetrack situation, where they had to close. So let's assume the only reason for closing was the potential of having lawsuits, because that was mentioned, the potential of having lawsuits. I would say this, because it was mentioned what racetrack had done. So if the potential of having lawsuits while they closed, one of the things that was mentioned was that they had great camera system, they had security, they had all the state-of-the-art things, great lighting. So if it was only the potential of having a lawsuit, I would say there's actually hope for the racetrack to where we could bring these people back, and it's in the SB 223. Because if you do all of those things under SB 223, you get a rebuttable presumption that can only be overcome by clear and convincing evidence. No frivolous claims would be coming through that type of legal standard. So if you're doing all those things, I would tell everyone who's listening today, if you want racetrack to come back, but you also want people who are harmed to have an opportunity to go to court, this isn't the bill. Have persons who voluntarily do great lighting, voluntarily have great camera systems, voluntarily have a security, as was mentioned racetrack would, and they would get a rebuttable presumption against any liability that could only be overcome by clear and convincing evidence. No frivolous claim could make it through that kind of standard, and people who are really wrongfully done, they would still get access to the courthouse. With that, I yield the word.
Recognize the senator from the 42nd.
Thank you, Mr. President. So I'm not a lawyer that's out there fighting insurance companies. I'm not a lawyer that gets to go defend insurance companies. I'm just a little country lawyer. Yeah. As a country lawyer, there are farmers in this body that have nicer shoes than I have on. But I just want to take a second, because everybody else is talking about this bill, to say a few words, as hopefully we're about to wrap it up. This bill is not perfect. I had a lot of concerns about the original draft of the bill. I still have some concerns about this draft of the bill. But I've yet to see a bill come across our desk or come across this floor that I thought was perfect. I also appreciate our Lieutenant Governor, and I appreciate our Governor for allowing the legislative process to work. We've had a lot of noise, especially the last 24 hours and the last couple weeks. Got a lot of nice mailers to my house. Got to hear my name on WSB radio driving up to the Capitol every morning and back home. Yeah. But despite all that noise, all the threats of don't do your job, better vote for this bill, or your political future is going to be in trouble. Despite all those threats, I appreciate our Lieutenant Governor, and I appreciate our Governor. I appreciate the Senator from the 50th, our pro tem, and I appreciate this entire body, because I believe you're going to vote with us on an amendment soon. Amendment 1 makes this bill better, but Amendment 1 also says that the Senate has a job to do. And despite all the noise, despite all the threats, we're going to do our job. And so I stand today, I could go through the bill and tell you what I like and don't like, but what's more important to me is I'm proud of this body today. Thank you.
The old farm boy from Henry County has yielded. You got them $4,000 alligator skin cowboy boots on? Oh, me. All right, let's get this wrapped up here. The Senator from the 27th.
Thank you, Mr. President, colleagues. Good morning, good afternoon. I'm not sure where we are at this point. There's been a lot of talk about insurance companies this morning, and I will speak only for myself, but I have heard from exactly 0 insurance companies about this bill. But I will tell you about 3 people who I have heard from. I heard from a business owner in my district last summer who I'd never met before in my life, who called me out of the blue and asked me to go to lunch. And he is a distributor of building materials around the southeast in the state of Georgia. And he said, I've never been politically inclined. I've never met with a state senator or state rep. In fact, I didn't even know who you were. And so I looked up your name to figure out who I could talk to explain the peril that we are in with the rising rates of insurance. And the feeling that I have a target on my back every day when I send my trucks out around the southeast. They have taken the logos of their company off of their trucks because what they found was that people would pull in front of them and stop quickly and then file a lawsuit thereafter. I heard from another gentleman who does not live in my district, but he was aware of the work that I'd done on premises liability over the last couple of years, and he called me and drove up from the city and sat down with me and explained to me that he is in the low-income housing business. He said, we are making a decision as to whether or not we are going to keep our portfolio of low-income housing assets or whether we're going to sell them because we cannot get assault and battery policies underwritten on our insurance policy at all. So due to the premises liability precedents that have been set in the state of Georgia, the insurance companies are telling us that we'll be completely exposed to any assault and battery that may happen on our property, and frankly, we are afraid that that will cost us our business. And so if we do not see tort reform happen in the state of Georgia, we will be forced to sell our assets. And most recently at a dinner party with some friends, I had a friend who I've known for a long time who's never talked politics with me. He is a small independent insurance agent who underwrites business policies. And he says he has lost count of the numbers of insurers that have left the state of Georgia due to the current tort environment. And he said, I don't know what all you all can do, but please help us. I think everyone knows that we have a problem in the state. In the first few weeks of session, there was some posturing as to maybe the insurance companies are the sole problem. And I don't know to what extent they are or are not a problem. I'm not going to argue that fact today. But what I think is very interesting is this morning we saw leadership from the minority party drop a premises liability bill, which is an acknowledgement that there is a problem. Now, we can get into the nuances of whether this bill is better or that bill is better or bills that have come before are better, but let's at least recognize and agree that now we have bipartisan acknowledgement, that at least as it relates to one portion of this bill, that there is a problem in the state that needs to be resolved. So the question then becomes, how do we solve it? And I would propose that there are two paths before us, and we actually saw those two paths play out this morning. Governor Kemp looked at this and recognized that we had a problem. I'm sure that he has heard from 1,000 times more business owners and industries than I have. And I want to give him credit for the way that he has navigated this process. He has identified this as his number one priority for this year. But I would like to remind you that he identified this as a priority for last session. And after he realized that this needed some more time and some more data, he pulled back on that last session. We passed 1114, instructing Insurance Commissioner King to get us the data. The governor then spent the summer and the fall traveling the state, which, by the way, to the members of the minority party, that was an opportunity to engage with the governor and his team. And as I understand, there was not a representation from the minority members of the Senate at any of those meetings anywhere around the state, all of which were open for you to participate in. I also understand that the governor has met with, I guess, as the chief of staff for the minority party's leadership twice. The governor's staff has met with. The minority party was given a copy of the bill before the bill even dropped. So I think it is patently unfair to come and state that the governor has not been willing to negotiate. The governor has removed entire sections from this bill through the negotiation process. Last evening, the governor's staff fundamentally changed the phantom damages piece and component that we see in Amendment 1. They have literally done nothing but negotiate for the past year and a half. The only thing they've done other than negotiate is travel the state to get information. But the governor recognizes that we have a choice. Doing nothing is not a choice. So we can choose to follow the path of California, or we can choose to follow the path of Florida. And we have members of this General Assembly of this Senate this morning that are advocating that we follow the path of California. You have an amendment before you that literally is asking you to do what California has done. Cap rate increases. Provide artificial pricing mechanisms from the state to cap the rate increases. Let me tell you how that's going to turn out. This is from the Wall Street Journal 4 days ago. California Insurance Commissioner Ricardo Lara last week announced a $1 billion surcharge on private insurers and their policyholders to prop up the state's wobbling insurer of last resort, which is their state insurance mechanism. Forget the private insurance companies. They are down to the insurance company of last resort, and they need a $1 billion surcharge to prop them up. Meantime, in California, State Farm General is asking regulators for an emergency 22% rate increase to avoid a, quote, dire situation. What is the dire situation they are trying to avoid? Is a credit rating downgrade for State Farm that will require homeowners in the state of California to leave the private insurance market and go into the state insurance market. And the senator from the 7th has brought you an amendment that would ask us to go down the path of California. A couple of years ago, Governor DeSantis in Florida charted a different course. He looked at the same problem in a state, by the way, that has a lot of natural disasters, very similar to California. And he said, I'm going to bring tort reform to the table. I'm going to bring lawsuit reform to the table. I'm going to look at the tort environment in our state and figure out what the mechanisms are that we can implement that will balance the scales of justice, still give people their day in court, but also get rid of the things that are causing the rising insurance rates. And we have seen a number of downstream implications that I'll talk to you about in a second, but I would highlight that moment to tell you that Governor Kemp has chosen wisely in choosing the Florida path. The Florida path did not result in immediate insurance increases. The senator from the 7th is correct about that. I don't think that if we pass this bill today, insurance rates will go down tomorrow. Why? There's an underwriting process. There's a risk assessment process. There are things baked into the system that need to be accounted for. But what the senator did not share with you is what is happening this year in Florida, 3 years after their tort reform bill passed. Geico has filed for a 10.5% rate decrease this year in the state of Florida. Progressive Auto has filed for an 8.1% rate decrease in the state of Georgia. State Farm has filed for a 6% decrease in the state of Georgia. Why? Because 11 new insurance companies have entered the market in the state of Florida. And we hope that is what will happen here in the state of Georgia. Part of what was in 1114, by the way, that we passed was the requirement that the insurance companies, in their rate renewal process with the insurance commissioner, state the impact of tort reform on their rate changes. So moving forward, should this bill pass, we will indeed see the insurance companies telling us what the downstream implications are of the decisions that we made this session. Lastly, the previous rate increases in the state of Florida averaged 21%. Sounds familiar. They were in a similar state. They passed tort reform. What did it do? It addressed phantom damages. It addressed premises liability. It addressed a number of other things. Does that sound familiar? Their 21% rate increases came to an end after a couple of years, and the average rate increase across all types of insurance through the entire state of Florida this year is not 21%, it's not 11%, it's not 5%, it's not even 1%. It is 0.2%. It is the lowest insurance rate increase in the entire country. So like Governor Kemp, colleagues, we have a choice today. Do we want to go down the path of California, or do we want to go down the path of Florida? And I would tell you that on this decision, like most decisions, we will be much better served to go down the rate of Florida, down the path of the rate of Florida than the path of California. Thank you, Mr. President. I yield the will.
Senator is yielded. Senator from the 36. You have a parliamentary inquiry, state inquiry.
Isn't it true that the gentleman who just left the well may be unaware of the fact that our Democratic caucus leadership offered the Florida model as a reasonable approach to the issues we've been discussing, and it was rejected, but that Florida model appears in SB 223 that our minority leader presented today. Isn't that true?
I'm not familiar with that, Senator, but if you say it, I have no reason to doubt you.
Thank you, dear Governor.
I've always told you she's one of my favorites. So, recognize the senator from the 16th.
Thank you, Mr. President, and I want to thank our governor and our lieutenant governor and our leadership for what they're doing and moving forth in this bill. I'm an independent insurance agent. I will tell you that I do not like to go see customers and present them with increases that are there or tell them I no longer can find coverage for you. We've got to take a move and do one of the things that Florida has done, and that is move forward. Move forward in tort reform. Here's what I will tell you. It's interesting. Insurance companies, who owns them? Well, if you're a mutual policy holder, guess what? You own part of that company. If you're a stock company, that's owned by the stockholders, owned by investors who put their money in, hoping they can make money. And if the returns that Senator from the 20th spoke about, the returns have not been that high overall. When we deal with the issues of insurance, we deal with this. Inflation has hit us in medical. It's hit us in repair costs. It's hit us in our cars. It's hit everywhere we've got. We have a basic influence of inflation that has affected everything that we do, and it is accentuated with insurance. Inflation is a part we've not addressed here. That I don't know that we can, but we've got to work to turn it around. Let's talk about something else, insurance. We criticize it a lot, but between this, we've got 2 back-to-back hurricanes in Georgia that are going to run $3 to $4 billion that have to be dealt with. California has far more, even 15, I'm hearing 15 billion or more for what they're having to have. And those rates, even what happens across the country, affects us to some degree. The greatest thing to bring down insurance cost, is competition. And competition is when companies want to come to Georgia and want to make money and can make money. And by making these changes we're making, it opens the door. We have companies leaving or just saying this: we don't want to write any new business in Georgia because of what they see. This bill, in my opinion, at least is the move to help what started in Florida 3 years ago. It's not going to happen fast. It's going to happen step by step. And this bill, in my opinion, is the start that we need to take now to deal with tort reform and move forward. If we are doing that, we're doing it for the citizens of Georgia, and they ultimately will benefit by our actions. Thank you, Mr. President, and I appreciate it.
Recognize the senator from the 14th.
Thank you, Mr. President. It was foretold that there would come a time in the land when the governor would exercise his political capital, and there would be opposition in the Senate chamber. But woe unto those Democrats who would speak in their own voice against the governor's bill. And blessed are those senators who can speak with a higher voice, a compelling voice, that doth protest in the face of tort reform. I want to read today from the chapter of Truth Social, verse Donald Trump in Florida. When the governor of Florida, Ron DeSantis, passed his tort reform, the one that has been extolled from the well this afternoon, Donald Trump wrote on Truth Social, Rhino Ron DeSanctimonious is delivering the biggest insurance company bailout to globalist insurance companies in history. The verse continues, the worst insurance scam in the entire country. We have a second scripture today. I want to read from the chapter of Donald Trump Jr., verse South Carolina. Hey, South Carolina, what's going on with this? This bill seems like a complete disaster. Hopefully, the legislature gets smart and strikes this down. The words of Trump for the people of Trump. I'm not going to say the last part. Thank you, Mr. President.
All right. Senator from the 18th, the Pro Tem, would you like to close the debate?
So there, Governor. Thank you, Mr. President. To the senator from the 14th, I really don't know what you just said, but you're entertaining. I'll give you that. Colleagues, I'm going to try to be brief, but this is important. There's some things we need to get through. There's 8 reasonable solutions to rebalance our civil justice system. They're contained in Senate Bill 68. Each have been carefully crafted by the governor's office. But first, I want to tell you, we've talked about those that this is for, but I want to make sure we remember it's for the folks that are in the gallery It's the folks that are outside this chamber. It's for the hundreds of people that came to the press conference, and it's for all of Georgia. That's why we're working on this issue. That's why we need to pass Senate Bill 68. You know, we had some incredible testimony that came before us over the last 2 years, from what happened at the Judiciary Committee hearing to the 3 roundtables that the governor held across the state. You know, we learned that eggs are not the only thing going up at Waffle House. Georgia accounts for roughly 22% of all Waffle House locations, but 37% of their litigation costs. The average cost of negligent security lawsuit for Waffle House of Georgia's, one of our finest dining institutes, is 5 times higher than it is in Florida. Georgia's 9 times higher than it is in Texas. Is 21 times higher than it is in South Carolina, and it is 27 times the cost that they deal with lawsuits in Alabama. Let's take another look at a great Georgia company. How about Coca-Cola?
Hold on one second, Senator. I'm sorry. Can we show the Senator a little respect in the well right now, please? He's almost finished.
Thank you, Mr. President. Comparing the cost of Coca-Cola to neighboring states when they have an issue involving one of their trucks and wind up in a lawsuit, the cost in Georgia is 8 times the cost it is in Florida. The cost in Georgia is 9 times the cost it is in Mississippi, 8 times the cost it is in Alabama. And finally, if you think it's just hitting companies, no, it's hitting everybody. Uber had some incredibly interesting information that they shared. Currently, 21% of the cost of an Uber ride in Georgia, when you get in one tonight or tomorrow or next week, 21% of the fare that you pay is going just to cover insurance cost. Just insurance cost. But maybe you say, well, but wait a minute, John, how does that compare to other states? Well, how about in Texas, it's 13% of the cost of the ride. South Carolina is 11%. Tennessee, 8%, and that same Uber ride in North Carolina, only 6% of the ride share goes to insurance. We had witnesses that came before the Judiciary Committee. We had one that talked about the desire to continue to provide low-income housing, something very much needed in Georgia, and how the insurance rates were getting to the point that they not only cannot continue to build and provide that type housing, it threatens the very basic economic model that they're trying to provide low-income housing to people in Georgia today. We had someone came that talked to us because he owned grocery stores. He came from very modest means, but was able to get to the point of owning a few grocery stores, and now he does. And I think there's some towns and maybe even a county in which he's the only grocery store in the county. And what he told us was, as I go to work every day, I used to go thinking, how can I grow my business for me and my family and my children? Today, he says, I go to work every day hoping not just to grow my business, I hope just to save it and hold on to it. I want to thank the senator from the 50th for his good work on the amendment. Amendment number 1 that I encourage you to vote for. I will tell you it is in accord with and a good landing spot, and that the governor agrees with this. I also want to thank the senator from the 42nd for his good work and willingness to engage in discussions. But I would tell you that the rules inside the courtroom are just as important as the rules that we abide by in this building. You know, we work hard to ensure that Georgia's laws are fair and reasonable and balanced, and this is just a continued effort for that. Like many pieces of legislation that pass through this chamber, none of them are really a silver bullet. But the facts are that are undeniable from what we've heard for the past 2 years through the filing of this bill to the vetting of this bill is that overall litigation costs continue to rise. The frequency of litigation is increasing, and competition in the insurance marketplace is fleeting because of the tort laws we have. And friends, the cost of litigation is just like any other cost. They're passed along to the consumer, and we're all paying it. I want to thank Governor Kemp for his thoughtful approach to this. I want to thank our Lieutenant Governor, our president of this body, for his good work on this and his thoughtful approach in getting us navigated to the point of having this bill. And I want to thank our Senate colleagues for their good work. I want to briefly address some of the comments that were made relative to Senate Amendment 2 and 2A. You know, the comment was made in the argument that claims to decrease insurance costs are not really valid and not really true, because this doesn't do anything to stop insurance premiums from going up. But in fact, yes, it does. I want to thank the senator from the 27th for articulating so well what's happened to our closest neighbor to the south when they enacted tort reform and exactly what happened on the insurance market. As he said, and as anyone with common sense will know, it doesn't happen overnight, but it happens within a reasonable period of time, just as that's happened. The senator suggested that this was, quote, all a, quote, manufactured crisis, close quote. Are you kidding me? Were you not at the press conference? Have you not attended any of the meetings that the governors held around the state to take input on what the problem is? And the numbers that you quoted on Florida are simply old and just simply wrong. Thank you again, Senator from the 27th, for correcting those. We're all paying for this excess of the system we live in. And as was so clearly articulated by the Senator from the 27th, basically, if you want the California model, if you want that disaster being visited here in Georgia, consider voting for Amendment number 2 and 2A. But I know, and you know, we don't want that. The senator from the 2nd had an interesting approach on this. Well, wait a minute. How about the letter on the desk from the insurance company saying the insurance premiums are going to go down? Where is that letter? Well, come on. Of course that letter's not here. No business that is run by prudent business people can tell you what their costs are going to be next year, and we haven't even passed tort reform yet, but they expect a letter to be on the desk? No business can guarantee that. But I thought it was interesting, the senator, my friend from the 2nd, said, quote, my constituents want insurance premiums to go down. Well, I will tell you, ladies and gentlemen, the only guarantee that I will tell you about insurance premiums is that if we don't pass Senate Bill 68, your insurance premiums and my insurance premiums and the rest of Georgia's insurance premiums will go up. It will continue. That's the only guarantee. You don't need a letter on your desk telling you that. Your common sense tells you that. And finally, where is your solution to the Democrats who want to come in and talk about some other bill that got dropped apparently yesterday? You know, the senator from the 35th, I appreciate the comments, and right out of the box said, you know what, Georgians deserve relief, but that Senate Bill 68 will prevent injured Georgians from getting relief. There were no details given, there were no explanation, and it's because it's not sensible. The comment was also made that the Florida rates won't decrease, or that they were decreased because it was subsidized by taxpayers. Where was the citation to that? No evidence, no details, not even a newspaper article. Again, common sense defies that. And to the claim that the Democrats were not included in the process, is any Democrat of this chamber really claiming that they didn't know about Senate Bill 68, that it was coming, that it was being considered, that after it got dropped that you didn't have a chance to sign the bill? Of course you did. And then finally, the last ditch effort of my friend the senator that wanted to talk about child care and workforce and other things. You know, there's an old saying about lawyers when they get in a pinch. When you're in the courtroom, you know, if the facts are against you, you pound the law. And when the law is against you, you pound the facts. And when the law and the facts are against you, you just pound the table. Well, I guess we just pound the rostrum when the law and facts are against us, because both are against the Democrats' position on this. The cost of doing nothing is incredible. Our system is broken. We've got to fix it. I'll tell you that voting no on this bill only benefits those that like to keep the system that we have. If you don't want more low-income housing in this state, vote no on the bill. If you're satisfied with the status quo, vote no on the bill. If you want to continue to have medical access denied to our people in the state, vote no on the bill. But on behalf of our job creators, our healthcare systems, Georgians across the state who have come to us begging for relief, I ask you to join me in supporting this bill. Vote yes on the friendly amendment number 1. Vote down the amendment 2 and 2A. Join me in restoring a reasonable balance to our civil justice system. Let's do the right thing for all Georgians. Let's pass this bill. Thank you, Mr. President. I yield the will.
The Senator has closed debate. We have amendments to now take up and either to adopt or not adopt. And we'll just go in order. Amendment number 1, authored by the Senator from the 50th. Is there objection to amendment number 1? Without objection, amendment number 1 is adopted. Amendment number 2A, authored by the Senator from the 7th. There is objection. All those in favor of amendment 2A vote yea. All those opposed, no. Secretary, unlock the machine. Senator from the 2nd, for what purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, it is not true that every state, Florida, Texas, Tennessee, South Carolina, all have lower insurance premium taxes than the state of Georgia. Is that not true, Mr. President?
The Senator is knowledgeable about what he speaks. On the adoption of Amendment 2A, the yeas are 21 and the nays are 33, and Amendment 2A has failed. Moving on to Amendment 2, authored by the Senator from the 7th. Is there objection? All those in favor of the amendment vote yes. All those opposed, no. Secretary, unlock the machine. On adoption of Amendment 2, the yeas are 21, the nays are 33, and this amendment has failed. Questions on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor will vote yea. All those opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 33 and the nays are 21. This bill, having received requisite constitutional majority, is therefore passed by substitute. Recognize the majority leader for a motion.
Thank you, Mr. President. I move that the Senate stand adjourned pursuant to Senate Resolution Number 6 until 10 a.m. on Monday, February 24th.
The majority leader has moved. Secretary, read the announcements.
Mr. President, the Rules Committee will meet upon adjournment in room 450 in the Capitol, and on Monday, February 24th at 8 a.m., the Appropriations Committee will meet in room 341 in the Capitol. That completes the order, Mr. President.
Recognize Senator from the 19th for an announcement.
Hey, members of the Senate, just a reminder, hope you enjoy your weekend. 8 a.m. Monday morning, 341, Senate full appropriations. Thank you so much.
All right. Well done today, Senator from the 18th. Well done, Pro Tem. Majority Leader has moved that Senate stand adjourned until Monday, 10 a.m., February 24th. All those in favor of the motion signify by saying aye. All those opposed, no. The ayes clearly have it. Have a good weekend.